Calling the matters of CP 2026-20, Jian Enterprises Limited versus Trinidad and Tobago Electricity Commission.
Good morning, everyone. Could all attendees please turn their cameras on, please? And could I confirm everyone is hearing me clearly? Okay, I will proceed with the introductions. So I am Scott Kuzanman. I will be presiding as your panel chair this morning with me, Ms. Sonia Garland-Kelsey and Mr. Raymond Smith, and we are ready to proceed with the matter this morning. And I have the appearances for the applicant.
Good morning, Madam Chair, members of the panel. I am Margaret Rose. I appear on behalf of the applicant Jian Enterprises with Ms. Dina Marie Smith. The applicant Jian Enterprises is represented here today by Mr. Peter Charles.
Can you please Rose and correspond at this time?
Good morning, Madam Chair and members of the tribunal. My name is Jared Jagru. I hold for Mr. Ganesh Saru. We're led by Mr. Ram Logan, Senior Counsel, and instructed by Ms. Asha Ramlal. With me this morning is Mr. Aaron Rigault and Ms. Arya Khan, who are attorneys from Freedom Law Chambers, assisting us with the matter. And we have Ms. Gabrielle Moore, legal officer from TNTech, as well as Mr. Mark Leslie.
So, Mr. Jagu, as we saw as well, Mr. Brian Karayan, Mr. Woods, I can't think how they would from TNTech.
No, Mr. Karaya is a recent graduate of the Human Law School. He is not yet an attorney, he's an attorney in waiting and assisting us as well. If, with your leave, we ask that he be allowed to observe today's proceedings.
Mr. Carrier. That is, yes, so we'll admit Mr. Carrier.
Thank you, Madam Chair.
We call up Mr. Captain Postnot. Being called as a witness again. We saw him on the link.
That is correct, Madam Chair.
Is he attending as a witness or is he?
Mr. Katik, no, please, Madam Chair. The witness is Mr. Mark Leslie, who's on the platform. Mr. Katik is attending in his capacity as a representative of the respondent. Madam Chair, we are losing the video at the moment, so I'm not seeing the tribunal.
Is that the same thing, doctors? You seeing us?
Yes, I'm seeing you, Madam Chair, but you are breaking up in terms of audio and you're also going still at times, still frame.
So what we'll do is that we will come off and we will rejoin. Just give us some.
Thank you, ma'am.
Thank you, Madam Chair.
Hi, good morning again. If at any time you all are getting a difficulty hearing or seeing us, please let us know. And we will make other attempts to see if we can deal with it. I see Mr. Ramlogan is on. Well, good morning, Mr. Ramlogan.
Good morning. Good morning to the members of the tribunal.
Good morning. As it relates to the other meetings for lockdown, while no limit is officers who don't have any direct contribution on the immediate representative, that perhaps they can look on via the YouTube or perhaps going to themselves. They have less faces on the right? So the doctor that I think one of the other representatives you have to take because so far is more, and we have the students and the attendees. So the other representative perhaps, yes, Dr. Rose, you're hearing us?
Madam Chair, if we seem to have the same difficulty on my end. Madam Chair, are you hearing me? Hello?
Yes, we're hearing you, but you're not hearing us.
Yeah.
Yes, we're hearing you.
We are hearing you, but on our end, it's coming across broken up and corrugated. You're actually quite good right now, but I like, we were not able to ascertain what you just said, to be fair. I don't know if my friends on the other side are having the same issue.
Yes, you're coming. It's broken up a bit, my lady. Unfortunately, it's broken up. It's broken up.
Okay, great. Good. So we will come off and we will switch the internet connection, perhaps. So we come off for a few minutes. We stand down, and we will in 10 minutes we'll come back on. Thank you very much,
Madam
for
Chair.
these facilities.
Thank you.
Good morning again. We'll just wait on Mr. Jadu and Ms. Mohan to turn their cameras on. Are you hearing me? Yeah. Yes, yes, sir.
Good morning, Madam Chair. We are seeing you much better, you and the members of the tribunal. We're hearing you. It did break up a bit.
Hopefully, hopefully it's a lot better. But do let us know if you all are not hearing us.
I think the
We were
fact that
still
we
at
the fact that we minimized the number of persons who are actually logged on would have created some space on the bandwidth so that the quality hopefully will improve. It's better than the last time, but in the interest of time, I suspect we might want to proceed and see how it develops.
yes. Thanks, Mr. Ramloban. I agree. So we're at the stage of dealing with the preliminary matters. All the appearances were announced, and we want to go through some preliminary matters before we proceed today. To confirm, Dr. Rose, you would have served on the respondent all the documents you filed.
Yes, we have, Madam Chair.
Great. Great. And Mr. Jaru, the same apply, you have served the respondent with all the documents you filed.
Yes, ma'am. Yes, Madam Chair. Since the filing of witness statements, we have been served with a supplemental witness statement. We have filed and served evidential objections and supplemental evidential objections in respect of the supplemental witness statement. We have received the applicant's submissions in response to the evidential objections, together with a bundle of authorities and a supplemental bundle of authorities filed this morning. And we have filed one supplemental authority this morning. And the applicant has filed an application for course. Those are the documents that have been filed since we filed witness statements.
Grateful, Mr. Jaru. Indeed. So as it relates to the supplemental bundle of authorities, leave will be granted for both parties to file the supplemental bundle of authorities on the 10th of August, 2026. We will put the order in the final order. Generally, as it relates to the bundle of authorities, it could have been done with the final closing submissions. As it relates to the evidential objections, we would then proceed to hear the parties on the evidential objections. I know Ms. Dr. Rose indicated she wanted to be heard orally. We would limit the parties to 10 minutes each.
I'm sorry,
So
Madam Chair. I had thought that since you had requested written submissions, that you would have dealt with it without my oral submissions this morning. But I'm prepared to stand on the written submissions, which are grounded in the regulation 14.6, which allows you to act without regard to technicalities and legal form, and you shall not be bound to follow the rules of evidence stipulated in the Evidence Act. And I know the panel is fully cognizant of its powers in this regard. And I stand on my written submissions that I have put in on the evidential objection. So leave it in your hands, Madam Chair.
Thank you, Dr. Rose. Mr. Jaru, do you want to add anything?
Madam Chair, we would just like to take the opportunity to respond to the reply to the response that has been filed.
Yes.
The order did say that both parties would be allowed 10 minutes. I don't propose to be longer than 5 to 6 minutes in reply, please, Madam Chair.
Yes, please. So you may
Thank you.
proceed.
Thank you, Madam Chair. There are two discrete sets of objections before the panel. One is the objection to portion of the principal witness statement, and the second set is the objections to the supplemental witness statement, paragraph 14 to 17, and the exhibits, the new exhibits, PC1 and PC2. The applicant, as we understand it, says, well, this is a specialist panel, not bound by the rules of evidence, and you can simply admit everything and give the weight that you see fit. But the fact that the panel is not bound by technical rules of evidence doesn't mean that there are no rules at all. It's not this hearing is not a free-for-all in which the parties can put opinions and legal submissions and in their evidence or witness statements, and then attach new documents and give rise to new issues in the witness statements. And then, say, well, we'll go to trial and let's hope for the best. Regulation 14.6, which the applicant rests their submission on, it's supposed to be an instrument of fairness. It's not a license to allow procedural unfairness in this case. Because in terms of the supplemental statement, we're being faced with documents which we did not anticipate would be relevant to this trial. And the answer that my learned friend says, that the applicant says is, well, we put it in and we'll cross-examine on it, but that doesn't assist the prejudice, because that doesn't allow us the opportunity to be responsive to those new documents or the new issues. In respect of the objections to paragraph 40 and 42, paragraph 55, 60, and 65 of the principal statement, we say that evidence crosses the line from evidence of fact into evidence of opinion, speculation, and submissions on issues which the panel has to decide. And we've identified what the precise basis of the objections are in our objections. I accept that a witness giving opinion evidence can give their opinion of things that they saw, heard, or felt. But that is not what this witness does. This witness attempts to interpret the legal agreement between the parties, evaluate whether Tiente correctly applied the agreement by reference to his own interpretation, and then give expert opinion evidence on the engineering merits of the respective proposals made by KVR and Jian. And that, we say, is not permissible. This is not Mr. Charles is not an independent expert evidence. He is the principal and owner of Jian, and therefore he cannot be considered in any form or fashion independent. And that alone takes away from the weight on which any opinion evidence that he purports to give should be applied. So it's not admissible, we say, on that basis. But then further to that, he gives no evidence of any experience that he has in engineering at all. So on what basis would the panel be admitting this expert opinion evidence? There is none. It would be different if you were to say, well, this is what I saw, felt, heard, thought, etc. But that's not what he does here. In relation to paragraph 55 and 60, the applicant says at paragraph 55 that he's comparing documents, and that they can infer from the re-evaluation of report that it's not an independent account. But so he may be able to say, well, I compared two documents and this line doesn't appear here, and this content is not in the second document, etc. But what he cannot do is use the witness statement to tell the panel this is the conclusion or inference to be drawn. Those are matters for submissions, and that is a matter for the tribunal to decide on. In relation to paragraph 65, we say that this again deals with the LIDAR system. The applicant seeks to characterize this evidence as skilled factual evidence, but we say there's a difference between explaining from your first-hand involvement in what you do as a witness, as opposed to someone proffering an opinion on what KVR did. And that's what Mr. Charles is doing. He's putting forward evidence in substance to say, well, this is what KVR did. This is how it compares technically with what Jian did. And these are matters of opinion upon which the merits of the contested technical evaluation rests. It's not a matter for him to say, and he can't speak about what KVR did because he wasn't there. So we say he's not an independent expert. He's not qualified to give that opinion evidence. And most of his evidence that we have objected to is in the realm of legal submissions and opinion evidence for which there's no foundation.
Mr. Chaku, before I proceed, just
Sure.
1 minute, please. Could you remind me of the paragraph you're referring to in relation to what KVR said? You're still on 55, or you're referring to what
No,
he said?
that's at paragraph 65. 65 is where he
All right, yes.
comments on the leader
Right.
and what Jian did and what KVR did and etc.
Yeah.
So he can't give that evidence. He wasn't there. He has not laid the foundation to give that evidence, firstly. And secondly, he wasn't there, so it's hearsay evidence in any event at its highest. And thirdly, he's not an expert. He hasn't laid any foundation for him giving this kind of expert evidence. He has not said he's qualified to give this evidence. So we say it should be struck out. Again, the upshot of what the applicant wants you to do is to say, well, admit it, give it whatever weight you want, but that's not a universal answer. It doesn't make a legal submission or speculation or inadmissible opinion evidence without foundation admissible. And it's not appropriate in this matter to clutter the evidential record by saying, well, we'll let it in and decide later what weight it deserves. Because the point is that there's zero evidential weight that you could give to this this proposed evidence. In terms of the supplemental witness statement, we say, well, our objection firstly is to the entirety of the statement. It comes too late in the day. It comes after the deadline for witness statements. And it really is not meant to correct or supplement what is in the principal witness statement. It is really an attempt to raise new issues that are not part of the agreed issues and put in documents that were not disclosed by the applicant to signal that they intended to rely on them. In the alternative, we say the specific portions of paragraphs 14 and 17 and exhibits PC1 and PC2. The record will reflect that these were not parts of Jian's pleaded case. The documents had not been previously disclosed. Purpose of saying, well, we're going to rely on this at the trial, and Jian has not had the opportunity to address that, these new documents. So the prejudice, we say, is large because evidence has already been closed. So we say the entire witness statement should be struck. In the alternative, the offending paragraphs that we have identified. The fact that I think the applicant has said, well, we had these documents from before, but that's not the point. This is a public authority with, and in this matter, the tribunal can take note that the record, the trial bundle itself is some 2,000 pages. So that saying, well, this is a document you had, that doesn't cure the disclosure issue that the applicant has. The point of disclosure is to tell me, signal to the public authority, I'm going to rely on this document and you better be prepared to meet whatever allegation I raise in relation to it. But they haven't done that. They've waited until after evidence has closed to raise this as a new issue. And we've been denied the opportunity to say, well, how do we answer this? Who is the appropriate witness to bring to respond? What other document may be relevant for the purposes of responding? At its highest, all we can do is make submissions on it, which doesn't really address the prejudice that I've set out. And then,
Mr. Jack,
yes,
you
please,
want to wrap up? Yes, that was 11 minutes right now.
one more matter. The material really seeks to resurrect the experience reference issue, which we say is not relevant for the purposes of this proceeding. And then the event it comes after the reevaluation period. It was not part of the previous evaluation documents that had to be considered in the reevaluation. Those are my submissions in reply. Please, Madam Chair and members of the tribunal, thank you very much.
Thank you very much, Mr. Jagu. Dr. Rose? Rose, you may proceed.
Thank you, Madam Chair. Thank you, Madam Chair. Sorry, we were turning on my mic. Please, may I have an opportunity to very, very quickly respond to Melinda Friend's submission?
Yes, please.
In respect of the principal affidavit and the paragraph relating 40, 41, and 42, this is not an issue of us saying you just deal with the weight. We are relying on the authority of Andrew Batiste, which we have put before the panel, and in it, where the judge clearly stated, warned against technical evidential objections carrying no real risk of unfairness, and recognized that a tribunal can receive evidence and assign it appropriate weight. So that this is a principle of law, a principle of evidence, and how we receive evidence into a matter. I think the whole objection in respect of 40, 41, 42, and 55 are covered by Andrew Batiste, and it's much ado about, and the panel can finish that statement, because at the end of the day, it may be that interspersed in those paragraphs, there are submissions, but again, you are a very experienced panel, and you are not going to make the determination based on what Peter Charles has said in a submission, but there are facts put before you. And as counsel, I will also be making those submissions. In respect of 65, I must counter very strongly on paragraph 65. We put before you in written submissions, and Melinda Friend has not made any attempt to deal with the case law that has been placed before the panel. Since what day was this? Friday. Yeah, was put before the panel. American Life Insurance Company and RBTT Merchant Bank, where Justice Abood held, and it's on all fours with the facts of this case, that job experience, familiarity with the subject matter, and participation in the transaction may make a witness a conveyor of skilled fact rather than an expert giving formal opinion evidence. And I'm saying that falls squarely in respect of the issue of LIDAR. This particular applicant and the representative of the applicant, Mr. Peter Charles, in his witness statement has indicated over 20 years of experience in this particular field. And I'm respectfully submitting that he obviously would be a witness of skilled fact, having regard to his experience in the field for over 20 years, the kinds of contracts he has been involved in, and he is commenting on LIDAR. And if the panel were of the view that you wanted to strike what he said about KVR, I have no objection to striking what he says about KVR, if that is the specific objection that Mr. Jaru is making, but certainly not on LIDAR. I think the Authority of American Life squarely covers him giving evidence of fact in relation to a security, surveillance equipment, which he is very experienced in. So that would be 65. In respect of the objections to the supplemental affidavit, again, much ado, and a lot of time going on this, and we have a lot to get through today. The reason for the supplemental affidavit was, one, to correct an error on his original affidavit, where under the paragraph relating to methodology, I think we put experience criteria 68 and 69. So we wanted to correct an error, which is obvious on the face of the record. So that is that but I see no prejudice to the other side, no real risk of any harm to the other side for the reproduction of exactly what is in their tender document. In respect of the PC1 and PC2, and we put it forward to complete the record. It really was omitted inadvertently. These are documents that are in the bosom of the of TNTech, of the respondent. I would say it is important for the commission, the tribunal, the panel, apologies, to have before it as much documentary evidence relating to this particular procurement process as is relevant. And we relied on the authorities. Yeah. And so we have put before you the authorities that we have relied on in this regard, and I would urge the panel to have regard to those. And those are my respectful submissions on the evidential objections.
Thank you very much, Dr. Rhodes. So we will stand down the matter for about 10 minutes to deliberate, and we'll come back with a ruling on the evidential objection.
Good night.
Thank you, Madam Chair.
So we return at, it is now 10:52. We return at 2 minutes past 11.
Thank you, Madam Chair.
Good morning again. So thank you for your patience. We have considered the submissions of the parties. We accept to a large extent Mr. Jagu's submissions that a lot of what he has indicated is objectionable was not directly relevant. We also agree with Dr. Rose that as a OPR hearing panel, we have way wider discretion than a civil court in terms of letting in what would have ordinarily been deemed inadmissible in a civil court. So what we considered more than anything else was the prejudice that may be suffered by letting in the various aspects of the evidence. So there are parts that we would have accepted, so we go through. As it relates to paragraph 40, paragraphs 41 and 42, the objection is overruled as we see no real risk of unfairness to the respondent, as well as 55, sorry. So 40, 41, 42, and 55, objection overruled. As it relates to paragraph 60, the objection is overruled, but for we would like struck out the first line that says from I do not until the word only in the second line. So we will allow from 2 months earlier, and we would allow the replacement of it to Tech, if that will make it clearer. In relation to 65, in line 1, we'll admit 65, but for the words of the type proposed by KVR, as it relates to the supplemental witness statement, we do accept that some of the information may appear to be irrelevant. However, we are working with limited time and we are not quite sure if it may be helpful to the panel. So, because there was no prejudice and considering the fact that the letters referred to and annexed to the supplemental affidavit, supplemental witness statement were in fact raised in the Form 9 of the respondent, I believe it would have been at 22-24 or so. The panel has decided that we will accept or we would not strike out the supplemental witness statement, specifically paragraph 40 to 70. Objection overruled. So we accept that those documents were not pleaded, but we noticed that they were in fact identified or referenced in the Form 9 of the respondent. So we don't see prejudice to the respondent.
Blind.
April.
Thank you, Madam Chair.
Yes, thank you. So before we proceed, are there any other preliminary matters? that the parties wish to-
Unfortunately, Madam Chair, yes.
Yes.
And
Yes, Dr.
I understand how this application will come across, given the tight deadlines and the time in which this panel will have to rule. I have considered long and hard as to whether to bring this application. And I have come down on the side that I must do it on behalf of the applicant. And the application that we would like to bring is an application to amend our Form 9 to include Form 8, to include an additional ground. Madam Chair, honorable members of the panel, please allow me just a couple minutes to explain why we feel constrained to make this application. And we understand that it is an uphill battle that we are coming to you with here. I start, Madam Chair, with the challenge proceedings regulations, which you are governed by. And that would be Regulation 15.2, which states that the decision of the office shall be confined to the issues raised by the application for review and written reply. We concede that the ground that we now want to raise has not been raised by the application for the review or the respondent's reply. We are asking your leave to amend to include this ground because this ground emerged from the filing of the respondent's witness statement, which we received on the 5th of August, which is less than 5 working days away from today. On the 5th of August, we were also in the throes of developing our skeletal submissions pursuant to this panel's order to be filed on the 6th. We were also, we had to consider that witness statement. We had to file our skeletal submissions. We had to also deal with evidential objections raised, also file on the following day submissions in respect of the evidential objections, and then also prepare the trial bundle. So I am very clear, I am taking it on my chest, Madam Chair and members of the panel, that having regard to the exigencies of the time frames that we are dealing with in this matter, it is only on reflection over the weekend properly of the witness statement of Mark Lessie that it has become very clear that there is another ground that we must advance. And I ground my application and ask this panel to exercise their power to receive this ground based on the overriding objective in the hearing panel rules, Rule 2.1, that the overriding objective of these rules is to enable the hearing panel to deal with cases fairly and justly. That is the overarching objective of the rules. And 2.2 says dealing with a case fairly and justly includes A, dealing with the case in ways which are proportionate to the importance of the case. And I would say that in respect of the importance of this case, if the hearing panel is has read the tender documents, this is the first 2 substations of a proposed project phased scope of over 133 stations. So we want to put before the panel that this is not just a one-off little $1 million contract. If you multiply $1 million by 133, you understand what we are dealing with, and perhaps that can signal to the panel the reason why this process has gone through what it has gone through over the time frame and why we are back here. 2.2b also says that dealing with a case fairly and justly includes avoiding unnecessary formality and seeking flexibility in the challenge proceedings. I also would like to refer the honorable panel to your powers under Rule 4.8, that you can regulate your own procedure and you can exercise any of your 4.9, any of these rules on your own initiative or at the request of a party. 4.10, 4.11 in particular, you may waive or vary any of these rules in respect of any challenge proceedings if it is of the opinion that to do so would be in the public interest or would be otherwise advisable to secure the just and expeditious determination of the matters in issue. So I put those provisions, your statutory remit, before you, before I highlight the ground that we would like to seek your leave to amend or for me to include. So that is your statutory remit that I know the panel is quite cognizant of. Madam Chair, if one looks at this witness statement of Mark Leslie at paragraphs 7 and 32, this witness has gone at length to stipulate what his involvement was with both the first evaluation process and the second evaluation process, and overall the tender process before us. The applicant could not have known, and this is the, yeah. Yes, Madam Chair.
If we are getting into the witness statement, perhaps we can ask the witnesses to step out to Mr. Plessy is here. Mr. Charles. And Mr. Charles.
Thank you. Thank you for that.
When we started, but yes. Mr. Leslie and Mr. Charles, we will let you all know, your various counsel will let you all know when you need to rejoin. And you advise, please not to tune in online.
Understood. Should I log off?
Yes, please.
Okay.
Mr. Charles, the preference is that you log off as well.
Yeah.
Oh, you move it, yes.
Yeah, so just log off. Madam Chair, I should say that Mr. Charles is in a room behind us.
I'm seeing him there.
And he's going to move.
So
He's going to move.
Yes.
But I wanted you to know that. And
Okay.
thank you for that, that guidance there with the witness. So, Madam Chair, when one looks at witness statement of Mark Leslie, which can be found at the trial bundle 1299, page 1299 of the trial bundle. At paragraph 7 and paragraph 32, the applicant could not have known the extent of the involvement of this witness in the procurement process. And so paragraph 7 and paragraph 32, if the panel would like to look at it, I mean, I have it in front of me, Madam Chair. And
Yes, we have it in the stance.
so we could not have known, and I would say, before I read the ground, that we do not have any factual evidence to put in response to this. This ground is based solely on the evidence of the respondent. The public body that has chosen not to put a record of procurement proceedings before you and not to lead a lot of evidence before you. Consider carefully what is being said at paragraph 7 and paragraph 13. It will be my respectful submission that this is an acknowledgement of breaches of procurement law on its face in the document. And so the ground that I'm respectfully asking leave to include a ground 2, which we have already drafted, and we had not filed this as a formal application because out of respect for my learned friend and for the panel, we felt we needed to make this application in the way that we are doing in front of you now. And if you grant us leave, we will file the ground. We can do it within minutes of if you were to grant us leave. I understand, Madam Chair, that we have a challenge with the time, and I was going to respectfully suggest that the evidence is on the witness statement of Mark Lessie, and it is basically a submission of law that my learned friends would require time, and we must acknowledge, of course, they would require time to respond to a submission such as this in law. And so we don't have much time, but I was going to, in any event, request of the hearing panel that we are able to put in written submissions for the entire, in respect of the entire matter, written closing submissions. And so perhaps the panel could consider it in the context of that, but I cannot, of course, organize the panel's thing. The ground, please, Madam Chair, if you would hear me, is the failure of the respondent to establish and maintain proper internal control systems and segregation of duties in the conduct of tender number 25030 in direct breach of section 5.1 and section 31A of the Act and the Office of Procurement Regulator General Guidelines and the framework of internal control for procurement. And the particulars of the ground, if you would hear me, Madam Chair, are as follows. The respondent TNTech failed to carry out the procurement and re-evaluation proceedings of tender number 25030 in a manner that is fair, transparent, and with integrity, thereby making a decision and taking action not in compliance with the Act. Specifically, the respondent permitted a single technical end user requisitioner, namely Mr. Mark Lessie, project manager and senior engineer, to systematically execute, direct, and control key strategic procurement, evaluation, and compliance functions. This systemic failure to observe and enforce the mandatory segregation of duties directly violates Section 5.1A and B of the Act, which mandates that a procuring entity carry out public procurement in a manner consistent with the objects of accountability, transparency, integrity, and value for money. Section 31A of the Act, which legally binds public bodies to comply. And so mandatory compliance with the general guidelines issued by the Office of Procurement Regulator. Then specifically Section 4.2 of the Office of Procurement Regulator General Guidelines in the Comprehensive Handbook and Appendix 3 of the Office of Procurement Regulator General Guidelines Framework of Internal Control for Procurement regarding the mandatory separation of requisitioner and procuring officer duties. 4, it also breaches Appendix 1, the RACI model, RACI model of the OPR General Guidelines Framework of Internal Control for Procurement regarding the exclusive statutory responsibilities of the named procurement officer. The specific particulars of the non-compliance of procedural unfairness. 1, the fusion of requisitioner and procuring officer roles. Mr. Mark Lessie, whose formal role on the tender number 25030, and I'm going strictly from the evidence as put before us before the public body, was strictly limited to that of a project manager, senior engineer, in brackets, an end user requisitioner. Acted as the de facto procurement manager. He personally drafted, this is what he said, and compiled commercial and legal bid documents, including the instructions to tenderers, form of tender, and general conditions of contract, and actively directed TNTech Supplies Department to advertise the tender while acting as the acting manager of that department. This represents a fusion of the requisitioner and procurement officer roles by passing the mandatory checks and balances required under Section 4.2 of the comprehensive handbook. Section 4.2 reads as follows: segregation of duties. In carrying out the procurement actions, the segregation of responsibilities for procurement is essential. The requisitioner, budget holder, procuring officer or buyer, payer, and the receiving officer should be separate responsibilities in order to provide appropriate organizational checks and balances and to permit specialization in their respective professional areas. This also aligns with the emphasis on accountability in the control environment. I will also refer the panel as well to the General Guidelines Framework of Internal Control, Appendix 3, Operational Framework of Internal Control for Procurement, Control Activities at page 55, where it identifies the risk of suboptimal or fraudulent procurement or disposal action due to an individual subverting the process. The mandatory control point here is establishing a systematic and effective segregation of duties. That is, distinguishing between requisitioning from purchasing and from receiving, and distinguishing between receiving and payment. Now, I don't necessarily want to go into the full submission on the ground, although we can do so if the panel would like to hear us on it. But there are further particulars. Let me do the particulars instead of the submissions. B, usurpation. So I said A before, which was the fusion of the requisition and procurement officer roles, which is what I just submitted on. B, the usurpation of the named procurement officers' exclusive authority to form committees. This witness has also spoken about he did all of this committee thing. Contrary to the OPR-RACI model, Appendix 1, which assigns exclusive responsibility for forming and appointing evaluation committees to the NPO, Mr. Lessie personally selected the members of the re-evaluation committee, drafted and issued their formal appointment letters, and set their strict guidelines. C, active interference with the independence of the evaluation committee during the active evaluation stage of the second evaluation, which is primarily before this panel. Mr. Lessie admits to reviewing the committee's draft re-evaluation report and providing guidance to the committee members during their active deliberations. This active intervention violates clause 24.3 and clause 43.1 of the OPR Ethical Code of Conduct, which legally obligates public bodies to allow evaluation committees to perform their duties independently, impartially, and free from any undue influence, pressure, or external guidance. And finally, D, bypassing the named procurement officer's transactional compliance and award controls. Mr. Lessie personally compiled a document bundle for the Procurement and Disposal Advisory Committee review, managed direct round-robin compliance feedback with the compliance manager and the PDAC chair, and pushed the contract award process along. Under the OPR-RACI model Appendix 1, only the MPO or designated procurement officers under a formal written instrument of delegation is authorized to review evaluation files for completeness and submit them to the PDAC. Now, Madam Chair and honorable members of the panel, I understand. You may see this as, what is this? The applicant is coming to drop in the middle of the process. As I said at the beginning, when the witness statement came to us, we were in the throes of drafting our skeletal submissions based on our Form 8, which is quite an intensive process, Madam Chair. And then we had evidential objections and submissions, and then the trial bundle and all of that. We have been under significant strain professionally on this. Malin Senior on the other side has a huge team with him. It's just Miss Smith and I. Miss Smith and I, it sounds like something, but yeah, it's just Miss Smith and I, Madam Chair, and I, on behalf of the applicant, I am asking this panel to exercise the very broad discretion that you have under the rules to treat with issues like this with flexibility so that the issues can be justly and fairly managed between the parties. For the panel not to give, we have regard to this, in my respectful view, it would be as if a witness, and it is a witness, coming to say, I've broken the law, I've broken the law, I've broken the law, I've broken the law, repeatedly before you, but because it wasn't in the applicant's application for review, you must turn a blind eye and say no. I would urge this hearing panel to understand that these challenge proceedings were never intended to be court matters. That was never the intention of the Act. The Act created a 20-day process for a reason. That 20-day process was to allow for quick and expeditious handling. We, however, have regulations and hearing rules that place a lot of pressure on representatives of applicants and respondents to treat with this matter as a full-blown legal case. However, these regulations and hearing rules must be subordinate to the Act and the intention of the Act. And the intention of the Act was to have these quick 20-day processes that the hearing panel can deal with flexibly. The hearing panel, honorable panel, you will understand that you are not, as a court, you are wearing a dual hybrid, you're sitting in a hybrid position because you are also inquiring into breaches of the law. This is what you are here to do. You are here to stand in the gap between public bodies.
I hate to interrupt my learned friend, but
Yes,
this is going to be, yeah, I hate to interrupt my learned friend, but I object because A, repetition, B, relevance, and C, this is now becoming a long-winded political speech rather than legal submissions. At the end of the day, my learned friend has to address you in the law. She's now arguing, not the application for for leave to amend, but what she's doing is arguing the appeal post the amendment being granted, which is not really proper in my respectful submission.
So other than the fact that I don't think it's political, I agree with Mr. Rob Logan. He kind of stepped in out of the rail.
Yes,
I think we have a gist of your position, Dr. Rose, and I would want to allow the respondents attorneys to give their view on it, because as you mentioned, we have limited time. So if we have to consider it, we want to hear the respondents, stand down and deliberate, and determine how we proceed with the matter. But I think, I believe, yes, Dr. Rose?
Just one last sentence, please.
Yes.
The reason for my submission was not to argue the appeal or even argue the ground, but to press on the panel to grant us leave to amend. That was the reason for the submission. So it is directly relevant to the exercise of the discretion that I'm asking the panel to make today. Thank you, please.
Mr. Logan or Dr. Jagu? Oh, Mr. Jagu.
I will want to say a few. I will seek your leave to say a few words before I hand over to Mr. Jagu. Melody, the first point is
yes.
What I agree with my learned friend on is that the Act and the regulations speak to the need for speed and expedition. And what my learned friend did not address is that consistent with that, there is a very stringent timetable set out in the law for these type of proceedings. In fact, if you don't bring your complaint within a specific time, 7 days within the standstill period, etc., you're out. And this tribunal has given many rulings on that issue. This is really an altogether new complaint that is going to be dressed up as an application for leave to amend. But the problem my learned friend has first and foremost, which she didn't address you, is how is this new complaint now, months after and outside of the prescribed deadline in the statute and the regulations, going to be entertained? Where do you get the jurisdiction in law to entertain a complaint that now comes outside the deadline that is disguised as an application to amend? So that's the first point, because the body and wealth of jurisprudence from the panel in its recorded decisions is that you impress the need for timeliness, a timely challenge, and if you're outside that time frame, out you go. A party is not entitled to file a complaint to bait and switch. This is what you call bait and switch. You file a complaint within the timeline, and then of course you switch lanes and then bring out an altogether new complaint outside of the timelines and seek to tell the panel it has jurisdiction. The panel has discretion, but discretion and jurisdiction are two different concepts in law. You can only exercise discretion if you first have jurisdiction. And this tribunal has ruled in many of its written judgments that there's a question of jurisdiction as to whether you can entertain the complaint outside of the limitation period, if I might use that term. But even if you can, the discretion in this case, it would be unjust and unfair for the following reasons. My learned friend has an entire speaking note and submissions. This is litigation by ambush. No one consulted us or informed us or notified us. We've come here prepared all night, and we've come here to do the trial. Time has been set aside. We've now lost a lot of time on this matter. And my learned friend did not give us any advance notification. She had the witness statement since August 5th. And today is the 10th. And she didn't make a written application. She didn't bother to write us to notify the panel to say that today is going to be completely wasted and dislocated and derailed, because they're going to pull the rug out from beneath our feet by making this application. Nothing of the sort. Our entire speaking note is done. It's not emailed to us so that we could prepare even to respond properly. The public interest cuts both ways. There is a public interest in when Parliament gave powers to this tribunal, it did so understanding that TNTech provides an essential service. And if it is, this is a second bite of the cherry for Jian Enterprises. And if we delay the work that TNTech has to do, that is detrimental to the public interest. And that is why the Act has a carefully calibrated timetable, and the deadline is gone for them to launch this new complaint that they now wish to. I think the fact that you're under pressure, Parliament would have considered that. We too are under pressure. It's a public authority with limited finite resources. The size of the team has nothing to do with it. I run an internship program at Hewing Law School, so we have interns observing. My learned friend has a large chambers just as well, and this is hard-fought commercial. This is a commercial matter. It seems that the Jian will continue to bring these matters, and the only time TNTech will get it right is when Jian gets the contract. That is the upshot of this, really. The only time TNTech would have complied with the law and gotten it right is when Jian gets the contract. Because this is the second bite of the cherry, and there was a carefully crafted consent order that was entered into by the parties, terms endorsed on counsel's brief. Now, Melody, the evidence in this matter is closed. And it does not lie in the mouth of my learned friend to say that, she's raising an amendment, an entirely new case, but that we will suffer no prejudice. If this has to go through, this upends the entire case. And of course, we'll have to reopen the evidence. Of course, we'll have to revisit a whole set of things. This is an entirely new case altogether. And the prejudice is obvious, both to the panel, we would have all read the papers and come prepared to do the trial. Why didn't Dr. Rose simply email even the panel or to say, well, listen, don't bother reading your papers because I'm coming to blindside everyone with an application that will obviously, as she said, we will need time to respond and all of that. I mean, you can't operate on an afterthought. The fact that the tribunal operates as a judicial or quasi-judicial body does not mean that there can't be rules. This remains an adversarial type proceeding. And the law on adversarial type proceedings, notwithstanding the fact that it's a judicial tribunal outside of the High Court, the fact of the matter is there has to be some rules that would govern the proceedings. If the evidence is closed, submissions are in, evidential objections are dealt with, the next step is to proceed to trial. It cannot be at that stage after evidence and submissions have been done and the evidential objections have been ruled on, you then come with this application. Obviously, it is an altogether new matter. And, we say that the tribunal should not entertain it, and that or the application, which is not formulated in writing, no prior notice and so on, should be dismissed. I will let Mr. Jagru have his say on the matter, but those are my thoughts. But we have to be careful, my lady, that we don't allow this to become something that is not illegal hearing. Not because you have relaxed rules of evidence mean there are no rules of evidence. Not because you have an important discretion and judicial duty to perform means that we can have no rules, or else it will become a galloping horse without any reins in your hand, and it will be to the prejudice of both public authorities and alike the contractors. Let me ask this question: what if we had made an application to amend something? What would Dr. Rose's position be? That we were trying to switch our case in midair and do a U-turn, down an entirely new path. I mean, the unfairness is obvious and need not be stated. In our evidential objection, Mr. Jagger will take you to it. We cited the case of Talpada and the Secretary of Home State, and in that judgment, the court said that all types of hearings must be conducted in a way that there must be some procedural rigor and discipline. And we are fast approaching a stage where there is no procedural rigor and there is no procedural discipline. And I ask that I sound that note of caution because it is something that we have to be careful about, given the need for expedition and given what is at stake for both the public authority, the public, as well as everyone else concerned. I'm grateful.
Thank you, Mr. Robert. Mr. Jagu, do you want to add?
Madam Chair, yes, because I'm not going to respond and take up more time on Malignant Senior's submissions. I believe that I have made my submissions, but on a point of fairness,
Dr. Rose,
Mr. Jagu,
Mr. Jagu is finished, and then you get the complete submission from the respondent, and then you can respond for a short while.
This is the point that I wanted to speak about. Is it that this is how these proceedings are going to go? That every time the applicant makes a submission, two lawyers are going to respond, and we are going to have to. Yes.
In fairness to Mr. Ramlogan, Dr. Rose, in fairness to Mr. Ramlogan, I inquired which one of them would be responding, because this is something totally new that has come to us. So I afforded him the opportunity. Right. I know that both Mr. Ramlogan and Mr. Jagu may not have been prepared. Mr. Jagu may not have been prepared to deal with these submissions. And it was in those circumstances I asked whether Mr. Ramlogan wanted to say anything, please. Mr. Ramlogan intervening, I did allow you to give a complete submission. I just need to hear if Mr. Jagu have anything additional to add, and then we'll come back to you for your reply.
Sure.
But I'm certain that throughout the proceedings, as it relates to the hearing, the course examination, they would have decided which of the two counsels will deal with the matter. But
thank you, Madam Chair. I wanted clarification on that. Yeah. Got it. Thank you.
Thank you, Madam Chair. Now, the panel has dealt with this issue of a belated amendment in the Class 1 case that we dealt with earlier this year. And in that case, the panel did refuse the belated amendment. And that amendment was sought at a CMC before the trial. Now, one of the things that the panel considered was that there may be there's no express amendment power in the rules, and that any amendment would depend on the promptitude of the matter and at what stage the amendment comes. Here, we are in an even worse stage than in class 1 because we are not even a day or two before the trial or at a CMC. We are at the day of the trial. And the applicant has not provided any evidence explaining this belated application for an amendment and why it comes so late in the day. The applicant couches it on the evidence from the bar table that, we've had a lot going on and a lot of work and etc., etc. But I think we are all familiar with the propositions from Kevin Matthews and the AG that says, heavy workload is not really an excuse. There's nothing exceptional about that. This applicant has had the re-evaluation report since the 10th of July. It filed its Form 8 on the 17th. Our reply was filed on the 23rd of July. There was a CMC. The evidence in the matter was filed and served by the 5th of August. We're now 10 days later. My learned friend has had the opportunity to file a supplemental statement, which the panel has allowed. They have been allowed the opportunity to file evidential objections. They did not. So this idea that they have been prevented from dealing with whatever they think or say is new in the evidence of Mr. Leslie, that's just not on. It's not procedurally correct. And they have had the opportunity to either one, respond because they put in a supplemental statement, or two, object if they found that it was something that was not part of our reply. And they did not. So we say that if what Jian wishes to argue is something new, a new ground at trial will inevitably prejudice Clientech because we have not had the opportunity to determine what evidence, what documents, or what witnesses or submissions are required to answer it. We'll have to effectively, we can't proceed today. And the allegations that my friend made, I mean, we haven't seen them formally, but the potential particulars seem to target Mr. Leslie personally. So it is not just a matter of law. He will have to then explain what he did, why he did it, and perhaps if the amendment proceeds, whether or not that was lawful. So this is an entirely new case that we have to answer. So while the applicant hinges its application to amend on, flexibility, that's not a license for procedural indiscipline, and we rely heavily on the Talpada case. The proper exercise of discretion for this panel, we say, is to refuse the amendment. You should dismiss this oral application and proceed to determine the substantive matter, which is before you, which we are all prepared to deal with today. Unless I can be of no further assistance, these are my submissions.
Thank you, Mr. Jadu. Dr. Rosary, you could have a brief reply.
Yes, very briefly. Neither of the counsel on the other side have grappled with the point that we've made, that this new evidence has come from their side on the 5th of August. When a friend, Mr. Jagru, sought to just say we had 10 days to address it, we did not. We had 3 working days, in which time we had several submissions pursuant to this hearing panel's proper orders. We make no issue with those orders, but we were engaged in those things, and this was the first working day occasion to raise the issue. I understand the difficulties that Millen and friends have with this, and so I am certainly not going to sit here and submit that they will not be prejudiced and not have to respond to this. And I understand that the panel needs to make a decision by the 14th. I had to consider my responsibility to my client, the applicant, where on the face of the evidence produced by a public body, they are admitting certain things. What are we to do? Ignore it? I have to put on record, because we do not know where this will end up, this application to amend based on the evidence put forward by this public body. We will not be seeking leave to put any evidence in response. Well, friend Mr. Jagru also spoke about we didn't object and we didn't come. What is that? We are not objecting. We want the truth. We want to understand what happened with this procurement process and whether this applicant was treated fairly in this process and whether the public body breached or did not breach the law. And I'm saying on the face of the witness statement, and the witness will have an opportunity to explain his own witness statement under cross-examination. My respectful submission is this is a submission of law based on their own evidence. And the witness can respond to questions put to him while he is in the box. Now, on the jurisdiction point that Learned Senior Counsel has raised, we have crossed the jurisdiction point already by bringing a formal application within the appropriate time frame. Within the standstill period, we brought an application. So there is a lawful application for review with appropriate jurisdiction before you. This is not an additional complaint. This is an additional ground being advanced within the context of an application for review that is properly and lawfully before you. I understand the difficulties with this application. As I said, I thought long and hard about bringing it, but I weighed. Yes. I thank you. I leave it in the panel's hands to determine what is the right thing to do, having regard to your statutory mandate.
Melody, I just wanted to say one thing, and just to make it plain for the record, that we simply do not accept the allegation of the evidence revealing breaches of any law. We do not accept it. We reject it outright, and we are disadvantaged by not having the opportunity to take instructions to be able to properly respond. My learned friend has analyzed the evidence to make that submission, but I want to be careful in saying that we reject that outright and completely. But it's just that we've been blindsided by this.
Very good. Right. So parties, we would stand down the matter for 10 minutes. So at just about actually 2 minutes past 12, we will resume. So just give us some time to deliberate on the submissions and we'll get back to you. Thank you very much.
Much obliged.
Good morning, everyone. Then, good afternoon, sorry. But Mr. Ramdu will be joining us.
Good afternoon, Madam Chair.
Yes.
I just saw that he's not connected. I will message him, but we're ready to proceed in his absence if the
So,
panel is
great.
ready.
Good. So thank you very much for the submissions for both sides. The parties, the hearing panel considered submissions for both sides, and we would dismiss the oral application of the applicants to amend the grounds on the basis that one, first, we consider promptitude. The act provides that we have to provide a decision within 20 days. In the grand scheme of things, or considering the 20-day time limit, the 5 intervening days from the 5th of August, when the witness statement was received, to the 10th of August, today's date in which the application was made, is a substantive time period within which this application could have been made. The issues could have become apparent on the drafting or preparation of the submissions, and we believe that the applicant did not act with promptitude. Further, the applicant could have given an indication to a friend or the hearing panel that this application would have been made this morning. We also consider fairness to the parties. In relation to the respondent, we considered that the witness, Mr. Leslie, would have to be allowed to respond on the basis that the allegations or the new ground, the amended ground, the proposed amended ground, may have serious implications for Tech as well as him. So we don't think it would be fair to allow it at this stage. As it relates to fairness to the applicant, we also consider that the applicant's sole ground is extremely wide, and will allow us to consider all breaches of the Act. So we do not believe the applicant would be severely prejudiced by not admitting it at this stage. We would elaborate on the reasons in our written decision.
Much obliged, Madam Chair.
Very good.
Thank you,
With
Madam Chair.
that being said, thank you, Mr. Jabu, Dr. Rose. We are in a position to proceed. Are your witnesses ready? We can confirm, Dr. Rose, your witness.
Yes, please, we are
Charles.
ready.
Right, and Mr. Jagu, your witness is ready to proceed today as well.
Yes, please, Madam Chair.
Right, so we'll start off with Mr. Charles.
So no opening submissions, Madam Chair.
Oh.
Have we lost all that time?
Well,
Lost all the
we
time.
have spent a significant length of time. We can give you all a 5 minutes if you all are inclined to make an opening submission. I actually forgot about it, but if you all are inclined, we can you can start, Dr. Rose. 5 minutes, please.
5 minutes.
Yes, please. As we get into opening submissions,
Or should we waive
should
the opening submissions then and do the closing then? We do closing, full closing.
Well, you all have the option to do full written closing submissions in any event.
But would
As
we have
one
an opportunity
submission.
to do oral closing as well? Because I do think we need to orally submit on this case. Well, I will,
Well, we can. While we are on the issue of submissions, and whilst we were going over the reasons for, well, at least when we are deliberating on this matter, the parties are reminded for future that when we ask for skeleton submissions, we really would be content with just skeleton submissions. Right?
very well.
It is just to guide the issues because you're going to be allowed the opportunity to write full submissions. Similarly, the authorities, the applications this morning to file supplemental authorities, you all could have done it with the closing submissions as well. So, Mr. Jacob,
very well. So in the interest of time.
Um,
Well, in the interest of time, oh, sorry, Mr. Jagu.
Madam Chair.
Here, Mr. Jacob.
I'm happy to do a brief opening. Alternatively, I understand the panel which will direct at the end of the trial for written closing submissions, and we expect that that will be comprehensive having regard to the evidence that whatever comes out in the cross-examination today. So my position is I'm prepared to do a brief opening if the panel so desires, and at the close of the trial, we do the full written submissions for the assistance of the panel.
I think I've got
And
your
ma-
preference to get written closing, right? Then at the end, it could be a lot at the end, and we can have the brief openings to start. In terms of the oral submissions, we do the written submissions at the close, and you all can be allowed to do the opening now. So, Dr. Rose?
So
That's fine with you? Yes, you
Do
can
the
have 5
opening?
minutes to do.
proceed with the opening?
Yes,
Now,
yes, please, Dr. Rose.
okay. Brief, 5 minutes. Madam Chair, honorable members of the panel, this application is about tender 25030 for the 1 minute. Apologies. Yes, this is for the upgrade of the IP video surveillance system for the respondent, and phase 1 was advertised publicly in August and 2025, and we are now almost a year into this tender process. This applicant is a seasoned over 20 years experience in this particular industry with clientele nationally and internationally in respect of this type of good works and services. And I would just want to make some brief comments about this matter, what it is about and what it's not about, because when one looks at the submissions of skeletal submissions of learned friends on the other side, they spend a lot of time, in my respectful view, on matters that there is no dispute, that we have no dispute on. And so I would just like to take a few minutes just to crystallize what the points are that we need to get together on, and the panel will have to resolve. When I looked at the facts of this case, I would like to call this case the case of the recurring zeros. The case of the recurring zeros. Because Jian, this respected supplier with the clientele that he has over 20 years and working in the oil and gas industry, when juxtaposed against the awardee in this matter, the awardee has no references in Trinidad and Tobago, all references in Jamaica, and had a price that was approximately 200,000 more. We are not submitting that the lowest price was supposed to get it, but I'm giving you a high-level overview of a very experienced contractor with a price that is approximately 200,000 less than the awardee has been given no less than 5 zeros across 2 evaluation processes. In the first evaluation process, he got 0 for not having a method statement, which he in fact had. That is not in dispute, because in the second evaluation, the method statement, which got 0 in the first evaluation, then got 10 marks, full marks, in the second evaluation. He also got 0 in his referees, 0 for a referee who did not respond, and the 0, according to their own unpublished scale, was for poor performance. So a referee did not respond, he got scored 0 for poor performance. A referee responded and confirmed that he was a contractor, oil and gas sector, multinational company for 7 years and still presently doing so. He also got 0 for poor performance. So those were the 3 zeros in the first evaluation, which Jian challenged. And in this evaluation process, so across two evaluation processes, he now gets 0 for ease of expandability and ease of implementation. I'm not going to go into the evidence at this opening, but suffice it to say at this point is that the reasons given for these 5 zeros over these two evaluation processes were either non-existent, no explanation has been given to date on how you ruled that there was a method statement that was missing. You did a certificate of truth saying a method statement was missing. You did a witness statement saying the method statement was missing. All of that in the first challenge. And in this one, no reference to it at all, no explanation for that at all, and no explanation, or it's either there's no explanation for the zeros or the explanations are irrational. And I will, at the close of evidence, seek to submit before you why, in my view, the zeros provided or scored on Jian were irrational, procedurally unfair, and in breach of the Procurement Act, the regulations and the guidelines as we've stipulated in our submissions. And we are saying for this reason, the two back-to-back evaluations in this single process, an inference can be drawn that there was some outcome determinative approach taking place. Because when we look at the evidence, and I would submit to this honorable panel that there is only one witness of fact in this matter before you that was present in both evaluation processes and was present for the presentation and demonstration criterion, which is of great dispute here, how that was it. There's only one witness of fact in respect of that. And that witness is the applicant, Mr. Peter Charles. And in response, we have a curious witness statement of a Mr. Mark Lessie, who, as we will see, we will seek to understand a bit more about what he did in this process. But what is this case not about? Very quickly, what is it not about? It is not about fraud or corruption. We make no allegation about that. We make no allegation about that. We've been very careful to say that the facts, the primary facts that are already in evidence, there's no gotcha in this case, honorable panelists. There's no gotcha. Like, oh, I can change this. It's squarely on the witness statements that have been put before you. All of our submissions are based on the witness statements that have already been put before you. And in those witness statements, there are primary facts, which I will submit at the closing stage, that point inexorably to one conclusion, that there was a decision that KVR was better. And in the second evaluation process, which you are primarily concerned with here, they were determined to give it to KVR. And I will show you that on their own evidence, please, Madam Chair and members of the panel. What is this case not about? The case is not about the lawfulness of the terms of the agreement that the parties entered into in the first challenge proceedings. It's not about the lawfulness of the terms. Because on both parties, sorry?
Which is at 8 minutes now, so.
Oh gosh, and I'm just going to finish on that point. Please allow me to close that point. It's not about the lawfulness of the terms, because both parties agreed that they entered into a contractual arrangement. Both parties agree that this contractual arrangement was binding on them. So it's not the lawfulness of the terms that is an issue here. It is the lawfulness of the interpretation of the terms that the respondent seeks to place on that agreement. It's the lawfulness of the interpretation and the lawfulness of the implementation of the terms that we join issue with. And you stopped me on time, but I want to just refer you to just one paragraph because I really want to urge this honorable panel that I have a lot of respect for, not to fall into error here. In the skeletal submissions, I refer you to the skeletal submissions of the respondents at paragraph 29. I have to refer to it in the opening because it's a little, it's dangerous. I do not want you to fall into this situation where at paragraph 29, what this respondent is suggesting is the court, they're telling you that when parties compromise agreements and enter into consent orders, although this is not one, and we have submitted on that, and I'm not going to go into that now, they are suggesting to you the court is not permitted to go behind the terms and conditions of a settlement order, nor is it entitled to question the reasonableness or commercial expedience of sale. Its role, and so they are suggesting to you, honorable panel, that your role is instead limited to ensuring that the parties abide by the terms of their consent order. Madam Chair, honorable members of the panel, I urge you, this would be a grave legal error for you to be persuaded by this submission. Your role is not limited to ensuring that the parties abide by the terms of their consent order. Your role is to uphold the law, the Procurement Act. Your role is circumscribed by the law. Was there a breach? Was there non-compliance? And section 6.1 of the Act puts it clear. Once this panel finds non-compliance, the process is illegal. And that is where I urge the panel to confine your deliberations to your statutory remit. Do not be led into error with the red flags, the distractions that you're going to hear coming from the other side. And I only say this not to cast any aspersions on the Honorable French, but because of their submissions. Their submissions are saying that Jian wants to get the contract. Of course, Jian wants to get the contract, but we are not at all asking the panel to award the contract to Jian. Jian is only asking to be treated fairly and to be the subject of a fair process. And I will close my opening by saying that that is the question that I would leave in the minds of the panel. Has this applicant been treated fairly, procedurally fairly, in this tender process?
Thank you very much, Dr. Reeds. Mr. Jaku?
Thank you, Madam Chair. The this challenge before you can be reduced to one central proposition. We say that it is important to know that Jian, the applicant in this matter, challenged what we call the first evaluation. And rather than litigate that challenge to a judgment, the parties compromised it. Both sides abandoned their respective positions and agreed on a mechanism by which the procurement would proceed. This is what Jian bargained for, and this is what TNTech did. The difficulty for the applicant is not that TNTech failed to re-evaluate. Their complaint is that the applicant Jian did not win the re-evaluation. And the panel should be careful not to allow this statutory review procedure to become a ruling merits-based appeal where unsuccessful tenders repeatedly demand evaluations one after the other until it eventually obtains the contract. Now, it's important to note that in the first challenge, the panel did not determine the matter on its merits. Neither side obtained any ruling vindicating its positions that they advanced in those proceedings. So that the applicant cannot now treat allegations which it made in the first matter as though they are findings. They were not. And TNTech does not ask this panel to resurrect and vindicate its first evaluation. The purpose of the compromise was to put that dispute behind the parties and substitute a fresh process, a de novo re-evaluation. And this is important because Jian's own witness accepts that paragraph 3, 4, and 5 of that the agreed terms of the settlement were proposed on Jian's behalf. And the bargain which followed after the agreed terms is straightforward. Do the evaluation again with a new committee and do not use any undisclosed scoring machinery. That's what both parties, there was consideration on both sides for this. Jian surrendered its pending challenge and TNTech surrendered its entitlement to defend the challenge and the original award. Neither party gets to preserve its own position, and that is the nature of the compromise. Those terms are binding, and it represents a contractual compromise. I think I understood the applicant to submit orally just now that there's no claim that it's invalid or void or procured by any mistake. So that we all agree that the terms are binding. But what it appears to be in this case, in this new fresh challenge, is that Jian seeks to retain the benefit of the compromise where the second evaluation suits it or is more favorable to it, but escape those parts of the re-evaluation which are not favorable to it. Now, we had sent the supplemental bundle with the authority of Winston Gibson and the Public Service Commission from Privy Council, and we say that that is authority for the proposition that this binding agreement between the parties to dispose of the old matter, the first matter, it is not optional because one party may consider its wording unfortunate or its consequences inconvenient. So that even if Jian says no, that the agreed terms may be badly worded or produced an unforeseen evaluation or unfortunate evaluation that it's not happy with, that doesn't entitle them to rewrite the bargain after the revaluation takes place. Now, the contradiction, I think I'm being mindful of my time, but the contradiction becomes apparent when one considers the price complaint in this case. Jian complains because they say both KVR and Jian received 40 marks. But it doesn't lie in the mouth of the applicant to say, well, the score is unlawful when they reduce Jian's marks, but should be used when the marks are increased relative to our advantage. That doesn't make sense. That proposition can't carry them far. And that same cherry picking affects the presentation and demonstration complaint, which is the real issue in this case. They say that in the first evaluation, they got 9 out of 10, whereas now they're getting 2 out of 10. But they also ignore the fact that KVR outscored them in the presentation demonstration aspect of the first evaluation. So, and interestingly, Jian doesn't challenge either the price or the presentation in the first matter. So that it is perfectly possible for the two properly constituted evaluation committees to reach different evaluative conclusions on the same material. The question for this panel is not which committee do we prefer, or whether the panel itself would have awarded a different score to Jian. The question is whether the second committee's assessment was so irrational or in defiance of logic or unreasonable that no reasonable committee could have come to that conclusion. And the answer we say here is no. This is not a committee that acted arbitrarily. It gave its reasons for the manner in which it gave the scores. And its reasons really are engineering and operational assessments, which relate to the concept of ease of expandability, ease of implementation, and maintenance. They're not new criteria.
Mr. Jabu,
Yes, please, Madam Chair.
so you're now over 10 minutes now, which you have been empty. How long
Wow,
the time
let's
that
keep
you've
it.
read them? So, hope you're wrapping
I was
up.
keeping track. I think I'm at 7, but okay, Madam Chair, I understand. Just one last point on the public interest. The public interest is not just in, there's a wider public interest here because this concerns the upgrade of CCT camera systems for a public entity, which were approved for advertisement May 2025. We are now in August, so that this procurement process has been underway for more than a year. And TNTech is being denied the opportunity to protect its critical infrastructure by reference to these subsequent procurement challenges. So we say the statutory challenge process should not be transformed into an instrument for to allow a disappointed bidder to continue to have successive evaluations until the result changes in its favor. So there's a wider public interest in finality. So these are our opening submissions, please, Madam Chair. If I can give no further assistance to the panel.
The job. Thank you, Dr. Rose. Waiting for your first witness. Your witness, sorry.
We call Mr. Peter Charles, CEO of
Space.
Jian Enterprises.
He's going to join the link.
I think you have to let him.
Oh, you have to return. You're not skipping.
Or remember, he was out of the room.
Sorry. That's fine.
He's waiting for someone to let him in. Please.
We're not seeing him. Yes, we're not seeing him. Call it. Charles. This thing is. So we're not seeing him in the waiting room, and we've been sending requests for him to join. Without any response. Sorry. Yeah.
Am I permitted to pick up a book while we wait for the witness, Madam Chair? Can I pick up a
Yes,
book
yes,
that fell?
please.
Thank you.
Yes, sure.
Everybody.
So as soon as Dr. Rose returned, we will swear you, Mr. Charles. Mr. Charles.
Yes.
Mr. Charles, sorry, you're going to hear the oath from here, Secretary, and you will have to repeat the oath.
Okay.
Good afternoon, Mr. Charles. Please
Good
raise your
afternoon.
right hand and repeat after me. I state your name.
I, Peter Charles,
Do solemnly,
do solemnly,
sincerely, and truly affirm
sincerely, and truly affirm
that the evidence
that the evidence
I shall give
I shall give
to the hearing panel
to the hearing panel
in this case
in this case
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Good day. Could you please state your name and address for the call, for the panel?
My name is Peter Charles. My address is Falcon Heights, Goodwood Park.
And your position?
My position is CEO of Jian Enterprises Limited.
Now, did you have cause to settle a witness statement for these proceedings?
Yes, I did.
If you were made to look at it, would you be able to recognize it?
Yes, I will.
Can the witness be shown the witness statement of the 4th of August, 2026? Do you see this witness statement before you?
Yes, I do.
How would you be able to recognize it?
By my signature, and then
Okay.
and the
Can
front end.
do you see your signature, Mr. Charles?
Yes, I did, and I confirm it's mine.
So this is your statement?
Yes, it is.
With your leave, Madam Chair, we'd like to tender this statement as the evidence in chief, this witness statement, to serve as evidence in chief in this matter.
Please, with the statement of Peter Charles, sworn to and filed on the 4th of August 2026, is tendered as PC1.
Thank you. And Mr. Charles, you
Just PC.
had called. No, not PC1.
This PC,
Let's
sorry,
go
PC.
PCA and PCB then? Okay. Mr. Charles,
That's
you also had cause to settle a witness statement on the 5th of August, 2026.
Yes, I had.
If this were to be shown to you again, would you be able to recognize it?
Yes, I will.
By what means?
By the contents and my signature.
Do you see your signature on this supplemental witness statement, Mr. Charles?
Yes, I do, and it is my signature.
With the leave of the panel, we hereby tender the supplemental witness statement of Peter Charles to also be relied on as evidence in chief. The supplemental witness statement dated 5th of August, 2026 to also be tendered the use as an evidence in chief.
Yes, please. So the supplemental with the statement of Peter Charles, sworn to and filed on the 5th of August 2026, is tendered as PCB. Yes. You may proceed.
Then, Madam Chair, we tender the witness for cross-examination.
Mr. Jagru, your witness for court.
Thank you, Madam Chair. Mr. Charles, you are the CEO of Jian Enterprise, yes?
Yes, I am.
Okay, good. And you're also a director, correct?
Yes, I am.
You supervise the preparation of Jian's bid in this matter?
Yes, I did.
And you attended the presentation on the 19th of January 2026, correct?
That is correct.
You also instructed Jian's attorneys in the first challenge, 2026-18. You recall that?
That is correct.
And then you subsequently participated in the negotiation of a settlement in that matter. You recall?
Yes, I did.
Now, you would accept that Jian stands to obtain a contract in excess of 1.3 million if this present challenge results in an award to Jian, yes?
Could you ask that question again?
I'm going to object to that. I'm going to object to that.
Yes,
Question.
please, Dr. Rose. Mr. Charles.
I'm objecting.
Yes, please, Dr. Rose. I'm starting Mr. Charles to hold on the answer. You can start.
Yes, I'm objecting to that question. There are clear reliefs in
Yes.
our Form 8, and none of the reliefs have we sought for any award to be made to Jian Enterprises. So it's an unfair question to suggest to the witness that he wants the contract to be awarded to him.
Thank you, Dr. Rose. Mr. Jagger, you have any response?
I can move on, please. I have another question. I'll withdraw the question.
Great, thanks.
Would you accept, so yes, would you accept, sir, that Jian has a commercial interest in the outcome of this matter?
Yes, I have.
Correct. And you are not appearing before this panel as an independent expert, correct?
No, I'm not.
Good. Now, this, as we established earlier, this is not your first challenge. This is not Jian's first challenge that you have conduct of before the OPR, correct?
That is correct.
You would have no doubt in preparing for this challenge, familiarize yourself with the different guidelines on the evaluation of submissions and award of contracts issued by the OPR, yes?
Yes.
Good. And those guidelines speak to the different types of evaluation criteria. You recall that? You understand that?
Yes, I recall it.
Right. And in this case, one of the mandatory criteria that was disclosed in the tender that you responded to was price, yes?
Yes.
Presentation and demonstration, yes?
Yes.
Methodology, yes?
Yes.
Safety and experience. You recall that?
Yes.
So you understood that these are some of the basic requirements of the invitation to bid, yes?
Yes.
And you also understood that if you were not able to satisfy any of these requirements, your bid may not succeed, correct?
That is correct.
Now, in your paragraph 29 of your present witness statement in this matter, right? For the records, it's at page 1278. One of the allegations you made in that matter, well, Jian made in that matter, is that Tech had used criteria and methods of assessment that had not been published. Do you recall that?
I need to get reference on that exact section.
1 second. So at page 1278.
Okay.
Madam Chair,
Hold
can
on,
the
we would,
witness statement
Mr.
be pulled up?
Yes. Yes, I was about to say that we would put the witness statement up. Mr. Charles, could you also keep your voice up? I think you are sounding a bit muffled on my end. Look into
Okay.
the camera and you could,
Is
if
it
you need
better?
to refer to any document, yes. If you need to refer to any document, we will produce the document on screen for you. So we don't want you looking down into anything. Look
Okay.
into the screen.
I,
We're gonna put the statement up for you.
Madam Chair?
Yes, Mr. Charles. Yes,
Sorry.
you could proceed, Mr. Charles.
Thank you. So you see at paragraph 29, sir, where you say that one of the complaints in the first proceedings was that we had evaluated by reference to undisclosed criteria and methods of assessment. You recall that?
We're looking at 29.
Yes.
Yes, it is.
And then at paragraph 30, you say, well, Jian did not complain of its price score or presentation demonstration score, correct?
That is correct.
So for the purpose of the first challenge, you would accept that Jian did not seek any relief in relation to the price assessment or the presentation and demonstration assessment. You accept that?
Yes, I accept that.
And you are also aware that in the first assessment, KVR had outscored you in the presentation and demonstration assessment, correct? It had scored 9.5 and you had scored 10. Sorry, 9.5 and you had scored
That's
9.
incorrect.
Could you repeat that?
Sure. In the previous assessment, KVR had outscored you, scored higher than you in the presentation and demonstration aspect of the evaluation. They had scored 9.5, you had scored 9. You recall that?
Yes, I do.
So you would accept that in the first evaluation, KVR had been assessed more favorably to you, well, to Jian, yes?
Yes.
Good. Now, that's fine, Madam Chair, if we could just remove the share screen, thanks. Now, in the first matter, your complaint, Jian's complaint was that the criteria or machinery by which TNTech had used, had applied to produce the scores. Your complaint was that that had been published beforehand, yes?
Yes.
And you wanted a re-evaluation protected from what you said were the undisclosed devices used to score, correct?
Not quite. We requested the reevaluation based on information that was presented in our proposal was not taken into consideration.
Okay. You participated personally in the negotiation of the compromise, yeah?
Yes, we did.
You had attorneys acting for you in that matter, correct?
Correct.
And those terms of agreement were reduced into writing, yes?
That is correct.
You signed the terms on behalf of Jian, yes?
Yes.
You understood at the material time by signing that agreement that Jian was not pursuing its challenge in the number 18 matter, and instead agreeing to a re-evaluation, yes?
That is correct.
And the re-evaluation was to be conducted in accordance with the published criteria, namely price, methodology, presentation and demonstration, safety, and experience. Yes?
That is correct. We expected it to be transparent and fair.
Yes. And you recall in clause 3 of that agreement, it was expressly agreed that you would not, there would be no application of a scale or banded value that had not been published. Yes?
Yes, I believe so.
And clause 4 of that agreement prohibited the 0 to 150 referee scale for the methodology, yes?
I believe so, yeah.
And then clause 5 specifically said where a published criteria did not specify a methodology, full marks will be awarded unless TNTech
Since apologies, we lost connection. I believe the last question we heard from you, Mr. Jagu, related to the methodology.
Yes, I had asked whether whether clause 5 said it was agreed that they would not apply a published criteria that does not specify a methodology. And if there is none, full marks were to be awarded unless TNTech identifies in writing a specific feature which the bidder had failed to satisfy. And I believe, subject to correction, Mr. Charles said yes.
Yes.
Mr. Charles? Right, okay, so we can
Yes.
move on to the next one.
Good.
Thank you very much.
Thanks. Now, there's nothing in that clause 5, Mr. Charles, that says one obtains a more favorable result in the previous methodology then the higher score goes, correct? That's not there in the agreement.
Could you repeat what you just said?
There's nothing in the agreement that stipulates that all of this criteria that you're to be assessed by reference to the published criteria. There's nothing there that says Jian can cherry pick between the first and second evaluation, correct?
Yeah, that's correct.
And there's nothing that provides for the preservation of what may be the more.
Mr. Jagu, just 1 minute.
Sure.
Dr. Rose, sorry.
Yeah, Madam Chair, members of the panel, it's not an objection to Melinda French's questions. It's just I noticed that no TNTech representative is present and all of the other council are also not present. Has Mr. Jagu indicated why there's no TNTech representative present? There are so many of them here earlier.
Earlier forgive me, Madam Chair, but earlier when we were having the bandwidth problems, we said that anybody who was not directly engaging would observe the live stream. So on that basis, the other attorneys and interns from our firm are observing the live stream, and TNTech's representatives are also observing the live stream.
So, yes, Dr. Rose, that was indeed said. We can accommodate the representative online or 1 or 2 of the attorneys, but just we had a lot at the time. So, we could proceed unless you want to send them a message. We are fine with.
If the panel wishes for the representative, it was Miss Moore and Miss Mongol, I believe. Sorry, Miss Moore, the legal officer.
Yes. So you could pause to get this more online.
Yeah, I will ask her to log on, please.
Carla Mohan, sorry.
Sorry, yes.
Oh. Yes. Thank you.
Madam Chair, would you like us to wait until she comes on, or can I proceed?
No objections to us
Yes,
proceeding. I
Yes, you can proceed, just indicate to them that they're free to join, we let them in,
Yes, please, Madam Chair.
and you can. It was really directed towards the additional representative from Jian Tech as well as the interns, right? So
Thank
even
you, Madam Chair.
your instructor is also welcome to join.
Yes, please, Madam Chair, but I mean, I will ask her to log on. I see Miss Moore is present.
Yes. So you can
Right.
proceed when you're ready, when you're finished.
Thank you. Now, Mr. Charles, there's nothing in the agreement between the parties that says that the second committee is required to adopt the first committee's judgment, correct?
That is correct.
And there's nothing that says Jian is entitled to the higher evaluation that obtains between the first and second evaluation, yes?
That is correct.
And there's nothing that says that the price formula used in the first evaluation is exempt from clause 3, correct?
That is correct.
And there's also nothing that says the presentation demonstration component is exempt from the de novo reevaluation, correct?
Correct.
Now you understand that this is that the terms of the agreement were that all responsive tenders would be re-evaluated, yes?
Yes.
And it was to be done by a new committee who had not participated in the original tender, yes? Original evaluation, sorry.
Yes.
Now, the new committee was not appointed to simply correct the arithmetic or the scores that were given in the last evaluation. You accept that?
Yes.
They had to evaluate the tender afresh, yes?
Yes.
And you understood that this new committee could exercise a judgment different from the first committee, yes?
Yes.
And there was no guarantee or agreement to reproduce any particular score from the first committee, yes?
Yes.
And there was certainly no guarantee that Jian would win the bid, yes?
Yes.
So for example, in the original evaluation for experience, Jian got 6.4 out of 20, yes?
That's correct.
And in the re-evaluation, you have obtained 20 full marks, 20 out of 20.
Yes.
And Jian accepts that 20 and it does not ask this panel to restore the 6.4, correct?
Correct.
Now, in the original, in the first evaluation for presentation and demonstration, you
Mr.
have,
Jaco?
yes,
Mr.
please.
Jaco, just hold on 1 minute. Dr. Rose?
I mean, I really respect Melinda Friend and the Melinda Friend's approach, but given the time constraints that we have, I'm just wondering where we are going with this type of cross-examination, which is basically reading out the facts and that the witness have already attested to, and asking the witness to repeat and say yes, yes, yes. I mean,
Well,
I'm not sure what Melinda Friend is attempting to achieve by this. The
Melinda,
evidence is already in.
Yes.
Oh.
Dr. Rose, let me hear from Mr. Jaco.
well, that's not really an objection. There's nothing inadmissible or irrelevant or what I've asked. And two, it doesn't really lie anymore to the applicant to waste a whole hour about an application to amend before we start the trial to complain about time constraints. And in any event, I mean, it's premature for my friend to object now on the basis of time constraints. Nothing I have asked is objectionable, please, my lady.
All
Yes.
right, Madam Chair.
maybe
let's
this-
continue.
Maybe this is the appropriate time because I wanted to do it before. Kind of get an idea as to the time, the estimated
Lady?
time of the grievance was.
Madam Chair, I didn't intend to be more than an hour. I think I'm just about 15 or 20 minutes through.
Okay, and just before we proceed, Dr. Rose, do you think your
Yes,
cost could be confined to an hour as well?
No, not at all. Much less.
Much less,
Much
okay.
less. Yes.
Much less or much more?
Much less, much less.
Okay.
I will
great.
try to be
Okay,
15
right.
to 20 minutes or so with Mr. Leslie.
Okay, great. Good. So Mr. Jaku, Dr. Rose, I do hear you, but he hasn't said anything inadmissible so far. Once you stick with the estimated time per hour, right? It's up to him to use how we tend to use the time. We are prepared to give you all.
And I'm
So,
prepared
Mr.
to give
Jaku?
some of my time. I'm prepared to give some of my time to Mr. Jaku, since he says I've wasted so much time.
That is very considerate of you.
Thank you.
Jaku, you can proceed.
Thank you, Madam Chair. Now, Mr. Charles, we went through the first evaluation. Jian received full 40 marks for pricing under the first evaluation, yes?
That is correct.
And in paragraph 60 of your statement, you say you do not understand how TNTech could, in good faith, refuse to use a method when it previously defended the price formula. You recall saying that?
Objection, objection, please. That sentence in that paragraph was deleted. It was redacted.
Yes,
So
please. Yes. Yes, Mr. Jaku, we are struck it out.
Alright.
You object.
In light of
and
the-
we struck out that.
In light of the earlier ruling, yes, please, my lady. Thank you. I would have prepared this before. Thanks. Thank you for that indication. Right. In the first evaluation, Mr. Charles, in respect of presentation and demonstration, Jian received 9 out of 10, yes?
Yes.
And you accepted earlier that KVR had scored higher in that respect, yes? In the first evaluation. And you recall that one of the documents you received that you requested and received was the first assessment report, yes?
Yes.
In that assessment, the original committee, you will recall reading, the original committee had identified one of the disadvantages associated with the implementation of Jian's fiber installation, yes? You recall that?
I recall that was their opinion.
All right, and it deducted marks because of that fiber component, yes? Because they said it was more labor intensive.
Again,
recall that?
yes, I recall that.
So these installation implications for Jian's fiber installation.
Yes, Dr. Lewis, 1 minute, Mr. Jaku.
I believe Mr. Jagu is putting things to the witness that is not in evidence. So I think if he's going to put from the assessment report. Apologies.
No, these are
You should-
part
you
of
should-
the, sorry.
Just 1 minute, Mr. Jaku, Mr. Dr. Lewis, you're finished?
Yes, I thought that I heard a question that was unfair because it was putting something to Mr. Charles coming out of the evaluation report that he lost marks in the first evaluation because of it was fiber optics was labor intensive. Is that something like that you had said?
Yes,
Yes,
that's the question.
that was the
I
question.
said yes. The witness answered the question, and I mean, it is part of, just in reply, just to be fair to the applicant, it's part of their own Form 8 at page 24, and part of Mr. Charles' statement at 1274.
I don't think we would have said anything about the because of ABCD. So if he's putting what was in the assessment report, we have the assessment report. And it's unfair to put to the witness that you lost because of this in the form of words that Mr. Jagru sought to use to the witness. And the witness hasn't seen the document and the witness is saying yes.
So you can't show. Yes, thanks, Dr. Rose, I understand your objection. Mr. Jagru? Can we show the witness the,
Sure.
can you tell us exactly what
It's at
document?
it's at page 24. It's the applicant's application at page 24 of the trial bundle, paragraph 24.
Also, it's not in the witness statement.
No, but this is the applicant's own application and narrative of the facts.
Yes. 1 minute, please. Do you need to go up a bit and we will have it on the screen? Is it paragraph 24, is that?
Yes, please.
Question again.
Thank you. So can I proceed, please, Madam Chair?
Yes,
Yes, please.
sorry.
Thank you. Yes. So, Mr. Charles, you accept that the issue regarding the installation of the fiber, that was not something that was invented by the second evaluation committee, was it?
In terms of the more labor intensive for installation.
Yes.
Well, that was, again, I would state that is their opinion. We don't believe it's more intensive than what they're comparing us to.
All right. So your disagreement is therefore not that the installation was the issues with the installation were never considered. It's really about how much weight the second committee gave that feature. Yes.
In terms of being labor intensive.
Yes. You're not saying that your disagreement is not that this was not something that was ever considered before or that it's not relevant. Your disagreement is how much weight the second evaluation committee gave the fiber installation component, correct?
No, that is not correct. Our concern is the fairness of how they compare our installation to KVR installation.
Well, you, sir, were not a part of KVR's tender, making of their tender, correct, sir?
That is correct, but I'm fully aware of the technology being used.
Correct. And would you accept, sir, that, okay, Jian at present, right? You accept that part of presentation and demonstration, right? There are three subcomponents: professionalism, yes?
Yes.
Ease of implementation and expansion, yes?
Yes.
And maintenance, correct?
That's correct.
The need for a more labor-intensive installation would impact on ease of evaluation and ease of implementation and expansion, not so, sir?
That is correct.
Good. So
But
your
our
gross,
challenge is,
wait,
yeah, okay.
your gross really is, Jian's complaint really is not whether or not the committee could have considered the fiber installation and whether it was more labor intensive. Your complaint is really how much weight they gave that feature, isn't it, sir?
No, it's not. Our
No,
grouse
your answer
is
is no. Okay,
no,
no problem.
it's not.
So I want to take you then. You say that Jian's bid was technically compliant, right?
If I said so, I think TNTech said so.
Okay. Do you agree that Jian's bid was technically compliant?
Yes.
Now that was if a would you accept that technical compliance is different from the presentation and demonstration aspect of the evaluation?
Yes.
Good. So, for example, the CCTV monitoring system in this case could be capable of performing technically the monitoring function, but it could be more difficult to install than another solution, yes?
No, I don't agree with that.
You don't agree with that?
I don't understand your question with respect to the CCTV implementation
The
compared to what?
CCTV, the monitoring system that you propose, that a contractor proposed to install in this case, it can work. It could potentially serve the function that it's being procured for, yes? i.e. monitoring, yes?
Are you talking about our solution?
Yes. So Jian's solution may potentially serve the function for which it's being procured, yes?
Yes.
But it could be more difficult to install than another solution. You agree with that, sir?
I don't agree with it because the basics are the same. If you're talking about
Wait.
cameras, installation of cameras, we all have to do the same thing.
Yes, but some installations
Mr. Thakur, does our group
I'm objecting to this. I'm objecting to this line of question because he's inviting the witness to speculate on what would be more intensive than another person's submission and another bidder's submission. It is not fair to Mr. Charles to ask him to speculate on whether his installation would be more or less labor intensive than another installation.
Well, the problem,
Mr.
sorry.
Thakur,
Yes,
you can proceed, Mr. Thakur.
yes. The problem with that is that this is what the witness himself has sought to do at paragraph 65. And if I stand corrected, but the only words that were struck out from paragraph 65 were the words, I'll put it up here.
By the type proposed by KVR, sorry.
I'm just trying to find the page, please. Yes. At 65, the only words that were struck out were the type proposed by KVR. Yes? Madam Chair, I'm just seeking confirmation.
Yes.
All right, so the remainder, the evaluation report awarded KVR the full marks under the sub-criterion does not record that KVR solution requires any field infrastructure at all. So I'm here to ask him about the different types of infrastructure that could be installed. That's his own evidence.
I think to be,
Well, okay, so Dr. Rose, do you want to respond? And then we'll.
yeah, I think to be fair to the witness, he should be shown the paragraph that you want to cross-examine him on.
No, I can ask I'm asking a simple question. I haven't taken him to his witness statement yet.
And Madam Chair, in that paragraph, all the KVR references, what is
Do we all want the witness removed for this question? Going to
Yes,
this?
please. Yes, please.
Mr. Charles?
Yes.
I would allow it. I would, we are pressed
No,
for
no,
time.
no, 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 no. Hold
Okay,
on,
all
hold
right.
on. We have to be fair. Mr. Charles, we
Yes.
just wanted to look off. Either step out of the room, if that would be quicker, and we'll call you back and
Yeah, just
also
go out of the room.
see that.
Yeah, well, let me step out because it's harder for me to log on.
Yes. Just
Stay,
step out
stay in
and-
the rooms and step out physically.
Physically step out. Perhaps Miss Smith will call you when we are ready for you. Confirming that he's out, Dr. Rose? Can't see him from here. Right, so Dr. Rose, you can proceed.
I have made the objection. To me,
Right,
the question that was being asked was, so you are saying your solution was less labor, it's not another solution, it's more labor. I'm not quite sure on the question that it was being phrased by the minute friend. The minute friend was responding. So
So what was the objection?
but the objection was that the question was unfair to the witness.
And I've responded and said that it can't be unfair
Right, okay,
because
so-
the witness himself
He
has
just
said,
confirmed.
you
Right,
know,
so
at paragraph
our
60.
position, I would have to agree with Dr. Rose, because removing that line from, which you have asked for it to be struck out, the comparator. We've removed that particular phrase, which is the comparator. Without that phrase, there's no comparison. So your question should not be along the lines of whether it was more difficult than another. You should be restricted to his own tender. Right? The question was in comparison to another tender is unfair. Yes?
Madam Chair, I'm just seeking clarification. At paragraph 65, KVR is mentioned 3 times. The only
Yes.
way to struck out was the type proposed by KVR also in the beginning.
Right.
Right.
Yes,
But the
but that
rest
is the
of the-
only part it is. But if you look at it, that is the only place it is used in a comparison.
Well,
The references to KVR later on matters of greenbacks. They got full marks.
yes, and does not record that KVR solution requires any field infrastructure at all. He is commenting on the infrastructure that KVR could or would or may not have tendered on.
it's a fact of that is recorded in the re-evaluation report that the witness is repeating.
Yes, I would agree with Dr. Rose. The last we considered it, the last sentence records stuff that we could actually refer to the evaluation report and the student that is there. Those are facts that are
Right.
before the already. The first sentence, the part that, because you objected to this entire paragraph, what we struck out was the part related to the comparison.
Yes, I
So you cannot
understand.
be asked about the comparison. So you can be asked about, yes.
In respectfully, Madam Chair, if that is the tribunal's ruling, I will proceed.
So you can call Mr. Charles in. Objection upheld, call Mr. Charles and Mrs. Smith, and we can proceed.
Obliged.
Yes. Madam Chair, can I
Proceed,
continue?
Mr. Jian.
Thank you.
Yes, please.
Mr. Charles, we went through the previous components of presentation and demonstration, yes?
Yes.
One of those is ease of expandability, yes?
Yes.
Another is ease of implementation and maintenance, correct?
That's correct.
Jian, and by extension yourself, are in the business of supplying and installing CCTV systems, correct?
Yes.
You have your evidence is that Jian, and by extension yourself, have supplied systems to companies in the private sector, yes?
Yes.
In your own experience, would you accept that a potential customer will be interested in the level of infrastructure work that needs to be done for installation?
The infrastructure work by installation varies from customer to
I didn't
customer
ask
based
that.
on the infrastructure.
Sir, so that is one of the things that are relevant to our customer, yes? The level of infrastructure works, yes?
Okay, yes.
Good, because that may impact the cost, not so?
Yes.
It may impact the length of the installation period, not so?
Yes.
And all of those would impact the ease of implementation, yes, sir?
Yes.
Good. Now, at paragraph 65 of your statement, the parts that are not struck out, you purport to describe what a LiDAR-based perimeter detection system is. Yeah? Well, you refer to a LiDAR-based perimeter detection system, right?
Yes.
You haven't said anywhere what LiDAR actually is. You accept that, sir?
Well, I can tell you now if you're interested.
No, I didn't ask you that. I didn't ask you to explain. I said you haven't said that anywhere in your statement.
That is correct.
Now, you purport to give at the last sentence of paragraph 65 evidence about what KVR may or may not have included in their tender, yes?
No, well, again,
Objection.
I don't have
That's
it
an
in front of
unfair-
me. I don't have it in front of me, so.
Sure.
Mr. Charles, Mr.
I
Charles,
see.
hold on. Objection from Ms.
I'm objecting, it's an unfair, he's not purporting to give what he thinks KVR solution was. He is recording what was and was not in the report, the assessment report, which is part of the respondent's case. It's unfair.
Right. So, Mr. Jagrut, have you had a look at it? End of 65?
Yes,
Last
please, ma'am.
paragraph. Last sentence, sorry. Do you
That I'm
accept what
asking
your
you.
friend said, or do you have a response?
But I understand the objection, but perhaps I can just withdraw and move on. It's a matter for submissions.
Yes, that.
Now, so we established you don't actually, you talk a lot about the LiDAR, but you don't actually say what it is, yes?
Well, it was just referred to
Good.
LiDAR.
And
The LiDAR is laser detection and ranging.
you had an opportunity to explain your statement what this is, right? Would you discuss these different systems in your statement. So for example, at paragraph 21 of your present statement, the words seamless expandability, that relates to Jian's VMS system, yes?
Well, I believe that was stated by Tech in one of their evaluations.
Right.
And,
But it's in
and that is
reference to
correct.
it's in reference to the Jian's proposed VMS system. VMS means video management system, is that correct?
That is, yes, that is correct.
Now, the issue that was raised in by the second committee concerned the fiber-based perimeter intrusion detection system, correct? PIDS.
That is correct.
So VMS and PIDs are two different aspects of the system, yes?
That is correct.
Right. Adding cameras to a VMS platform is not necessarily the same engineering exercise as extending a fiber-based perimeter detection system. You would accept that, sir?
I accept that.
So that where the committee said that the VMS allowed cameras to be incorporated in later phases, that does not necessarily affect the implementation at later stages of the perimeter intrusion detection system, correct?
That is correct.
Good. Now, I'm just going through my notes. I know my learned friend is mindful of the time. You did not, there was no agreement between Jian and TNTech to conduct a new presentation, correct?
That is correct.
But that, I object to that. That is a question of law.
It's a asked and answered, please.
That is a
madam.
question of law. Okay?
That's not a question. That is a,
Okay, yes, okay, let me hear Dr. Rose, a question of law. Mr. Jabru?
well, my response, my lady, really is that, Madam Chair, is that it's asked and answered, and it's a factual question whether it was agreed or not. The witnesses answered no.
Well, I understand that the witness would have given his understanding of what the agreement is. But I agree with Dr. Rose that as to what was entailed in the actual agreement is something for the hearing panel to decide. What?
That I understand.
Well, as a matter of law, based on
Madam Chair.
what it actually says, the interpretation, I should say, of the various clauses.
I understand, Madam Chair. But again,
Mr. Jabru, bear in mind that the objection that the evidential objections made on behalf of the respondent did in fact center on the said issue.
yes, and the tribunal overruled them.
Yes.
So I have to ask him about it. Thank you, Madam Chair. But anyway, we have the answer, Madam Chair, and we'll make submissions on it. So
Proceed, sorry.
thank you, Madam Chair. I'm just going through some of my notes here to make sure that I don't detain the tribunal any further. In relation to the supplemental statement, your supplemental statement, Mr. Charles. Yes? Mr. Charles?
Sorry.
Your supplemental
question?
statement, you recall your supplemental statement?
Yes.
In that supplemental statement, there's an email sent by you on the 26th of May, 2026, yes?
Yes.
And PC2 is an amended reference list, yes?
Wait.
Now, those
Wait.
documents,
Objection. That certainly is not the
Yes,
proper
Dr. Rose.
characterized an amended reference list.
Yes, Mr. Jabru, you can put in the title of the document, use the correct title. That
sure.
appears.
It's amended contact information. Is that what you meant?
It says amended client reference list. So I said amended reference list.
Where did?
It's at paragraph
Mr.
16,
Jabru,
page 1290.
Noted. Noted.
yes. Yes,
Yes.
please. Proceed, Mr. Chairman.
Thank you. So those documents come after the tender deadline. You agree with me, sir?
Those documents were submitted to assist in the revaluation because one of the complaints was that the evaluation team could not contact some of the referees because initially we gave company telephone numbers. And in particular, Nutrin, at that period for the revaluation, had shut down. So it was to assist the second evaluation team to make contact with the referees.
So the information that you seek to send, that you seek to rely on PC1 and PC2, that information comes after the tender had been closed, correct, sir?
After the first tender, yeah.
Yes.
Yes,
And the
after
agreement you had was for the responsive tenders to be re-evaluated, correct, sir?
Yes,
It did not authorize any bidders to amend their tenders after closure. You accept that, sir?
yes.
But in any event, you went ahead and purported to, well, you went ahead and supplied this additional information after the tender had been closed. But you do not seek to set aside in this challenge the decision on the basis that TNTech failed to use the updated contact information, correct?
Well, I don't know what information they use in the revaluation. I'm not privy to that.
So, Mr. Chairman, we are like 2 minutes over the our time, but are you wrapping up soon?
Yes, please,
Yes.
Madam Chair. So, if you would just answer the question, sir, you do not seek to challenge the decision, the evaluation committee on the basis that they did not use the amended information that you sent after the tender had been closed, correct?
Correct.
Good. So I just want to put my case to you, and you can agree, disagree, or say you don't know, right?
Yeah.
I'm suggesting to you that Jian, the applicant in this case, obtained the re-evaluation, which is what it had agreed for, consequent on the compromise of the first action. Do you agree or disagree?
Could you repeat what you said?
I'm
That-
suggesting to you, sir, that Jian has obtained precisely the re-evaluation which it bargained for.
I disagree.
Okay? And I'm suggesting to you that while Jian wants to accept the increased scores on the re-evaluation, you're seeking to also reject the one area in which it has had a decrease in score. Do you accept that
agree.
or
I
you agree?
accept that.
And you accept that there is nothing in the agreement between the parties that mandated TNTech to accept the higher score between the two evaluations, yes?
Could you repeat?
There is nothing in the agreement between the parties that mandates TNTech to apply the higher score between any of the two evaluations.
I agree.
Good. And that I'm suggesting to you that the engineering installation matters identified by the re-evaluation committee, such as the trenching and the conduit and the fiber deployment, these are plainly matters that are relevant to the ease of expandability and ease of implementation and maintenance. You can agree or disagree.
I disagree with the process because this is where we believe the second evaluation is flawed.
Because your own disagreement really is with the weight that the committee has attached to those factors, isn't it, sir?
No, it's not the
Yes.
weight. It's not the
It's
weight.
not. You are actually inviting the panel to prefer your view of how those matters should be assessed. Isn't that true, sir?
No, we were assessed on the ease of implementation and maintenance and so
Sir,
forth.
you said no, and I'm moving on to put the rest of my
Okay.
case. Right? Your evidence, I'm suggesting to you that your evidence concerning the LIDAR system is not based on your own knowledge of the tender process in this matter. It's simply your own partisan opinion.
Repeat the question.
Objection. I'm objecting to that question. It is two-pronged. First of all, but it's, yes, I'm objecting to that question on basis it's complex. It's two-pronged, but also on the basis that if you're putting a case, one must have evidence to support the case that you're putting to a witness. One cannot just pull out of your hat statements that you're throwing at a witness. Are they leading evidence of that contention that Mr. Jagru is putting?
This is, again, paragraph 65, in which this own witness talks about the LIDAR system and about what may or may not have been done in other tenders.
Yeah, but you're putting to the witness where he is getting his information from, and he is not knowledgeable on what was going on. You are the one putting that to him. Is that your case? Do you have evidence of that?
We have objected on the basis that this witness cannot say those things. We have established that this witness is not an independent witness. And I'm putting to him, as I am entitled to, that this is simply his partisan technical opinion. He can agree or disagree.
I'm withdrawing my objection because of time. I think this is a matter for submission.
That's the headers.
So is that
Mr.
commentary?
Jagru,
Yes,
before-
please.
Mr. Jagru, could you break up the question first of all?
Sure. So your commentary at paragraph 65 about the LIDAR system, it is not based on your own personal participation in the tender process, is it? Yes or no?
It is based on my knowledge of what the LiDAR technology is and what is required to install that system in any
Okay.
client, any
So
implementation.
Good. This is the same LIDAR system that you have not defined or explained what it is, correct, sir?
I was not asked to explain it.
Good. Now, and I'm suggesting to you that your opinion, your evidence at paragraph 65 is your own partisan opinion. Yes or no?
Yes.
Good. Now, one more. And I'm suggesting to you that the evidence in your supplemental statement concerning the email of the 26th and the amended reference list, that is information that came after the tender closed. Yes?
Yes.
And you were not permitted to submit any new information after the close of the tender as part of the reevaluation. You accept that, sir?
Yes.
And this whole challenge that you have before the panel it's not arising out of any failure by Tiantec. It is rather your own or Jian's dissatisfaction with the evaluation, the assessment consequent upon the reevaluation. Yes or no?
Could you repeat that?
Your challenge is not based on...
Before you, Mr. Jagru, you're asking two questions in one. Do you
Sure.
break it up? What is
Sure.
the question about the challenge and then what it is about?
Yes. Mr. Charles, your challenge before the panel really amounts to Jian's dissatisfaction with the assessment scores after the reevaluation, correct?
Correct.
It is not based on any failure by TN Tech to actually carry out the agreed reevaluation. Yes?
I believe it's not. I believe it is because,
Okay.
so I don't agree with that. I believe it is
Alright.
because
Okay, that's fine. You disagree. I have no further questions.
Thank you very much. Any re-examination, Dr. Rose?
No re-examination, please.
Great. So we would have a break right now. Yeah. Oh, sorry. I forgot to ask the other panel members for questions. Let's go. You have some questions, too.
Thank you, Mr. Charles. I have a couple questions in three areas. First one relates to the consent order. On receipt of the invitation for revaluation, did you communicate with TN Tech on any clarification as to how it was worded that the order was by the OPR? Was there any communication on the part of Jian on that?
I don't believe we had any communication except what was in the consent order.
Okay, so you accepted the invitation as it was presented.
As presented, and as I said, to be, fair in terms of the revaluation.
So the question I want to ask regarding the evaluation, what is your understanding on the aspect of price as to what would be considered as most suitable?
On the aspect of price, based on their evaluation, I guess full marks, but at the end of the day, the question is what is the best solution or value to TN Tech?
So price is separate from value. Okay. But they say that what was the industrial factor, market factor, and most suitable was the criterion that was published in terms of how price would be assessed. What would be your understanding? What was your understanding of, because no requests for clarifications were made. What was your acceptance or understanding? As someone who has been in this industry for 20 years, what was your understanding of what most suitable? How did you interpret that?
Most suitable, as you said, could be as various values. Yes, price is one. How the solution solves the problems that the implementation is supposed to solve in terms of the security, CCTV, the perimeter protection. The reality is that even within the TN Tech solution, different locations will require different pieces of equipment. Camera is one, CCTV, perimeter detection is one. As a matter of fact,
Madam Chair, I don't think that the witness understood the question
okay,
still, even though the honorable member asked the
Well,
question twice. Okay. Oh,
Dr. Rose, you
Okay.
could deal with the clarification. Allow me to re-examine him if it's
Thank
not
you.
clear.
sorry.
Yeah, that's it. Okay. I don't think he understands either. So in the evaluation rubric, right, there are sections that would look at the technical and what the different solutions is. I want you to look at just price. So if I tell you I'm going to charge you $100 for something, right? And somebody else charges, say, 200. How do you evaluate in terms of the industry, the market, and then what the term most suitable means? What is your understanding of those three criteria?
Once the solution provides the what in this case what TNTech needs in terms of the CCTV and the perimeter intrusion detection, and it meets all the requirements that are requested, I believe the least expensive solution will be the most suitable.
Okay, so let me go to another aspect. There were 13 tenderers for this particular bid. Some were rejected because they were not pre-qualified, right? And your understanding of the industry competitiveness. You are the authorized representative for one technology, ARCIS, I think it's called.
Okay.
Okay, right. How many are there various solutions existing amongst all those 13 or the tenderers in the industry? Are there several different types of solutions?
There are definitely a lot of different solutions. Even for Jian, we represent maybe 4 to 5 of the leading manufacturers. We chose the one Archive because we felt it was the best solution for them in terms of their remote video surveillance. Some of the criteria we took into consideration was bandwidth between Trinidad and Tobago, and even between Trinidad and the outlying substations. In the world of CCTV, bandwidth, which is what the cameras need to stream the video from the remote location to the central server or VMS, is very important to ensure that the system works. The solution we chose allowed a variety of solutions or configurations where TNTech can now choose to stream cameras directly from a remote location to the central server, or if bandwidth was a restriction or limitation, our system could communicate with the remote equipment, and this is why we suggested in our option 2 that we reuse some of the equipment that TNTech has. So for areas where the bandwidth had limitations, we could have reused their equipment to get the same result in terms of the central monitoring and things like that. The other issue,
Okay, so,
sorry.
Okay, no, I don't want to get too deep into the technical.
Yeah, I know.
I'm just trying to establish that there are many solutions and some offer unique capabilities. Even within the own 5 that you said you have, the EAT solution, this is not an industry where there's a that it is an industry where there will be uniqueness across solutions.
To some extent, yes.
I'm going to go into something else. In the when we look at installation and implementation in the form of tender, just to clarify, my understanding is that TNTech specified a duration
Sorry?
of 15
I didn't hear.
The TNTech specify a duration for the installation. In the form of tender, there is a duration I saw where I think it's 15 weeks.
Right. Duration in terms of that may have been.
But the installation of the solution, you had to present an implementation schedule.
Yes.
Okay. And was that you were guided by a specified duration from TNTech of 15 weeks? Is that correct?
No. Those 15 weeks would include the sourcing of equipment from the vendors. This proposal to TNTech was based on the requirement where the vendor, Jian and the others, would train TNTech installers to install the equipment purchased. So that a big part of the solution was training TNTech technical personnel to install and maintain the solution ongoing. Now, the CCTV system is different to the perimeter intrusion detection system. In some cases, the perimeter intrusion detection system may be easier to install than the CCTV system, meaning that the perimeter intrusion detection system is designed to protect the perimeter or the fence. Once the fence exists, the sensor or fiber optic cable that is spoken about is easily run on the fence itself and just secured to the fence. So there's no installation of possibly infrastructure like poles, where in some cases the cameras may need to be installed. So this is where, to some extent, we disagree, or we don't agree with TNTech assumption that the perimeter intrusion detection system is, I forget the terminology that you use, it's labor intensive and all those other things. As a matter of fact, camera systems, depending on where the coverage is, would need a lot more infrastructure.
Mr. Charles, okay. That's I'm not going into that. I'm trying to understand, but you made a point which I didn't understand before, that you as the provider would not be doing the installation. You were going to be training TNTech personnel to install.
That's correct. That was part of the
so that places a very different concept of ease of installation, right? And I just wondered if we could clarify, because I'm pretty sure I saw that 15 weeks as a stated duration in your form of tender.
That could have been
the implementation time. Okay.
From order to delivery and training, yeah.
Okay. And then the final question I had, in terms of ease of expandability, TNTech's proposition is that they have 130. In your contract, there were 4 sites, 2 in Trinidad, 2 in Tobago, correct?
That's correct.
Okay, and the long term, this was phase 1, was to upgrade 133 sites. Is that correct?
That's correct.
Okay, so in that expansion, is it a replication of what is done on each site, or would there anticipated be like a mirroring on these additional sites as they go out?
Well,
In terms of expanding.
well, different sites will require different types, different amounts of equipment. Think of it as a camera, right? At home, depending on your size home, you may need 4, 5, 6 cameras. If you have a warehouse, right, that warehouse may need 15, 16 cameras. So that the site determines, to give you the best coverage, what type of equipment you need. As a matter of fact, to get the best solution, you may have different types of cameras, different types of other pieces of equipment. In the case of the perimeter intrusion detection, if it's a very large site, you may find that the perimeter intrusion detection that we propose is much easier than trying to cover it with cameras or a LiDAR system. But a LiDAR system is like a camera system. You need to install enough to cover the area that you want to cover or to protect.
I don't want to go into LiDAR because that's KBR's solution. But what I was trying to understand really, Mr. Charles, what I was really trying to understand, which I think you've clarified for me, is that those aspects of the expandability, installation, and maintenance would reside largely in TNTech's hands, right? I had an understanding. I thought as a provider it was entirely in your hands, but now I understand it. So I have a better clarification as to what it is. Can you confirm that?
Well, the reason why I think it was proposed like that was for TNTech to reduce their own ongoing costs.
Mr. Charles.
Yeah.
You cannot say why TNTech would have proposed it like that. Right?
Okay, sure.
Mr. Kalsik simply asked you if to clarify her understanding is correct. We're not getting into why TNTech would have proposed it. So what Ms. Kalsik asked you was very specific, and it was just basically a yes or no. She gave you her understanding as whether or not it's yes or no, whether or not that is correct.
Could you repeat the question? I'm sorry.
So the question is that the installation and implementation would reside within TNTech's resources. Your contract as a provider was to train them on your method, and then they would install and also permit them to expand it to their 133 sites or more.
Yes, that was correct.
Okay, thanks.
Yeah, so yes, Mr. Chagu.
I just want to seek some clarification. I know that the panel was referring to a 15-week period. The reference to that is really for the option 2 part of the tender, which was rejected. So I'm not too certain how far the answers and the questions previously would take us, because that 15-week, from what I could see, is for the option 2 part, which is rejected.
Mr. Charles had indicated that option 2 is not applicable, really. He said it was yes. Okay. Right. Chance, Mr. Charles, but do you have any of the parties represented have any further questions for Mr. Charles based on this?
No, please, Madam Chair.
No, please, Madam Chair.
Right. So at this time, we would take a break. We can take a lunch break of 35 minutes, and we could resume at about 2:36. Mr. Charles, you are relieved as a witness, but given that you're a representative, you can come back on when we resume.
Thank you.
But Dr. Rose, to confirm, this is the case for the applicant?
This
Sorry,
is the case for the applicant closed.
paper, please. So when we return, we will open the case for the respondent. So, okay, could we say 240 then? We return
Yes,
at
please, Madam
240.
Chair.
Paper.
Yes, please.
So, seeing all at 240.
Recalling the matter of CP 2026-20, Jian Enterprises Limited versus Trinidad and Tobago Electricity Commission.
Good afternoon, everyone.
Good afternoon, Madam Chair.
Mr. Jago, are you ready to open the case to the respondent?
Yes, please, Madam Chair. I had spoken to Mr. Lessie and told him to log on at 12:40.
Yes,
I'm going to
he is
just
logged on.
call.
So once we confirm that there are no other issues, there's no preliminary issue that you would want to read off the rules before we continue.
No, Madam Chair, I know I'm doing, but no more preliminary issues.
Great. Okay, so we let Mr. Leslie and we have it forward.
I'm just to inform the panel that Mr. Charles is sitting next to me here on my left.
Yes. Good afternoon, Mr. Leslie.
Good afternoon.
Mr. Leslie, you're about to be sworn, so the hearing secretary would read the oath for you. You are to repeat it, and then we will proceed with your evidence. Mr.
Okay.
Leslie,
Yes.
I omitted to remind the witness before, when you're asked to give your address, you can just give the address of your business, please, not your personal address.
Of course. Thank you.
I call upon the hearing secretary to read the oath.
Good afternoon, Mr. Leslie. Please
Good
raise your
afternoon.
right hand and repeat after me. I state your name,
I, Mark Lessie,
do solemnly,
do solemnly,
sincerely and truly
sincerely and truly
affirm
affirm
that the evidence
that the evidence
I shall give
I shall give
to the hearing panel
to the hearing panel
in this case
in this case
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Mr. Jagu, Mr.
Yes.
Rigol is sitting with your office.
Yes, please, Madam Chair.
Is it that he will be coming on as opposed to one of the other attorneys from this morning?
Yes, please,
So,
Madam Chair.
Ms. Khan, sorry. Yes,
In place of Ms. Khan, yes.
please, Ms. Khan. Lovely.
Thank you. Okay.
You may proceed.
Thank you. Sir, can you please state your name, address, and occupation for the tribunal, please?
My name is Mark Lessie. The address is 63 Frederick Street, Port of Spain. I am a senior engineer attached to the communications department of TNTech.
Thank you, sir. You gave an witness statement in this matter.
I did.
Would you be able to identify that statement, sir?
Yes, I could.
Or would you be able to identify it?
By its contents and by the presence of my signature.
Could the witness be taken to page 1299 of the trial bundle? That's your statement, sir?
Could you show me the signature, please?
That's at page 13148, sorry.
Yes,
That's
that would be.
good. That's your signature, sir?
Yes, that's my signature.
This is your statement,
And that is my statement, yes.
and the contents are true and correct.
Yes.
Madam Chair, with your leave, might the witness statement of Mr. Leslie dated the 4th of August 2026, filed on the 5th of August 2026, be tendered as his evidence together with the attachments thereto.
Of Mark Leslie, sworn to on 4th of August and filed on the 5th of August 2026, tendered as ML, together with the supporting documents. Ms. Rose, your witness.
Good afternoon, Mr. Lassie.
Good afternoon, Ms. Rose.
You are not the procurement officer of TNTech, are you?
As far as I know, no.
As an engineer working with TNTech, I think your statement said for 10 years or more. Is that so?
Yes,
And
10 years
like
in this
you-
position.
In this position, and that's communications, senior engineer in the communications department.
Yes, ma'am.
So you are familiar with electronic surveillance technology
Yes.
in your line of work.
Yes, I am.
So the company that TNTech decided to award this to, their solution was a LiDAR solution, correct?
Yes.
What is the LiDAR solution?
LiDAR solution is technology that is light detection and ranging. That's what LiDAR means.
Light detection and ranging. Yes?
Yes.
And how does the solution detect light within ranges?
Would you like me to explain how LiDAR works?
Yes, absolutely.
Okay, so in the simplest form, LiDAR uses light, pulses of light, to detect objects and to determine their range from the sensor that is sending out the system that's sending out the pulses of light.
Okay. And so where is the sensor in the system?
It depends on how your system is configured. It can be mounted anywhere that you can shoot those beams of light to detect objects.
Mounted, you say? So it couldn't be just flying around in the sky.
No.
So paragraph 22 of your statement, you went at length. If the witness can be showed paragraph 22 of his statement, it is at page 1299. And paragraph 22. You don't know what page. Yeah, 1313, apologies. 1313 is the page.
It's that page.
So you see at paragraph 22, you spoke about Jian, the applicant's proposal, and it's fiber-based and all of the implementation requirements. You see the list of implementation requirements. So tell me, it is true to say that LIDA would have implementation requirements.
Would you mind repeating that in a different way, please?
No, it is true to say that LIDA would have implementation requirements.
I'm not sure I'm understanding what you're asking me.
There would be requirements to implement LIDA.
What types of requirements?
I'm asking you if there are any requirements to implement LIDA.
Okay, well, if I understand what you're asking me, I would say that
Are
there
there
would be
any requirements to implement LIDA, sir?
there would be requirements to implement
Thank
any
you.
system.
Thank you. It's yes. Right? And in terms of installation, specifically, there would be requirements for the installation of a LIDA system.
If you're asking me a question, yes, the answer is yes, there would be requirements to install a LiDAR system.
Yes, I am asking you, but that's what I'm doing, sir. Okay? Let's not fall out. So there are installation requirements. And as you said earlier, the sensor would have to be mounted, correct?
Yes. Mm-hmm.
Now, it wouldn't necessarily be one sensor, would it?
Not necessarily. Dependent on how the
necessarily.
solution is rolled out, yes,
It could be more than one,
possibly.
possibly. How many sensors are required for Cope Station?
I don't know that I can answer that at this stage.
Something, what is stopping you from answering that at this stage?
The reason is that we are still in the midst of a procurement process, and the particular system will be dependent on what the provider brings.
Would be dependent on what the provider brings?
Yes.
So you are not in a position to say what the provider is bringing in this procurement process. That your evidence?
Given that we have not completed the procurement stage, I would say that I'm not in a position to answer that.
Because you don't know what, no, let's go through your reason for this. Because you don't know what the provider is bringing. This is what you said.
Mm-hmm.
Correct?
Yes, that's correct. Mm-hmm.
You cannot respond with a We are being recorded. You have to say yes, no, or some affirmative or negative response.
All right, thank you for that.
So you completed the evaluation process and decided to award to this company, KVR, and you don't know what KVR is bringing?
If I may, I would say that when the award is made, it is expected that KVR will do another look at the site, and they will determine how many sensors go down at the site.
Oh. So KVR didn't look at the site and tell you all how many sensors they were going to put?
I don't know that I can say that. What I can say is that KVR did attend a site visit and has proposed a solution.
But we would have to await until
Okay,
the
Dr. Rose,
contract.
Dr. Rose.
Yes.
Dr. Rose, I know Dr. Rose did see clarification, but we also need to understand. So, Mr. Lassie, when you're given a response,
Chair.
if you're saying you don't know, we need to be clear why you don't know. Is it that you do not have the information? Yeah. If to say simply that you're not in a position to answer this time, it doesn't really assist the panel. So we need to get a better understanding. So if you don't know, say you don't know. If you don't recall, say you don't recall.
All right,
But
will do, ma'am.
to say you're not in a position to, the point of coming here today is to give the information to assist us to come to a determination.
Understood.
Right? So if you are able to get the information, you need to tell us why. Is it that you don't know, you don't recall, it is not within your not somebody else has the information, but we can't just say you're not in a position to give that information because it comes across if you don't want to disclose the information. Right?
Understood. Okay.
You can proceed, Dr. Roos.
Thank you, Madam Chair. And Mr. Leslie, it's not that you don't want to disclose. That's not true, correct?
That is correct.
You want to help this panel to understand the process that your public body was engaged in, correct?
That is correct.
Right. So you've given your evidence that upon award, they would come to the site and then you would have the final of how many sensors, correct?
That is correct.
Right. Now, each sensor would have to be mounted
Yes.
on something.
Yes.
On a pole. What would it have to be mounted on?
Given that I'm not familiar with the details of the system that they have presented, I would say I do not know at
Okay,
this stage.
all right. All right, so you are not in a position to speak to the installation requirements for the LiDAR system. Is that your evidence? Is that your evidence, sir?
I am not in a position to speak to those requirements at this stage.
Okay. And it is true to say that you did not attend the presentation demonstration that occurred on the 19th of January, 2026.
That is true. I did not attend the presentation or demonstration.
So you've given a lot of information in your witness statement about the presentation, demonstration, and what the evaluation committee would have been thinking about in terms of the applicant. All of that is what was told to you, correct?
That is correct.
Now, I noted in your statement with respect to this presentation demonstration criterion, you said that in paragraph 17, which would be page 1312. Okay. 1311. Starting at, you said that no additional information was put before the evaluation committee. This is what was told to you, correct?
Yes, ma'am.
And they relied exclusively, I want to be fair to you here, on the information contained in the original tender submissions, yes?
That is my understanding.
Together with the presentation material, yes?
Oh, yes, yes,
Attendance records
yes.
and contemporaneous documentation generated during the evaluation, the original evaluation process. Is that correct?
That is my understanding, yes.
Who told you that?
This was based on my interaction with the chairman of the committee.
The chairman of the committee told you that.
Yes.
You did not see any presentation material, did you?
Myself, no, I did not see that material.
And in fact, when was the tender closed in this matter, in this process? The date
Just to
for the
clarify,
submission.
are you referring to the original tender closing date?
Yes.
Right, so.
There's only one closing date in this process.
Right, so we're talking about the 4th of November, 2025.
Correct. And are you familiar with public procurement requirements and best practice and whatnot and law? Are you?
Specifics of the law, I cannot say that I am.
Okay.
Some aspects
But-
of practice from guidelines provided internally in the commission, I can say yes.
Okay. And so would you say that after the closing of submissions of bids, that bidders would be allowed to submit any additional information?
Could you clarify that, please?
Okay, we're speaking about good procurement practice,
Yes.
which you said you would know a little about.
Mm-hmm.
Is that being fair to you?
Yes, that's fair.
Right. So the submissions closed November 2025, you said, yes?
Yes.
And is it, in your understanding, good procurement practice, is additional information received from bidders after the close of tender submissions?
Additional information, I'm not sure if I'm clear on what you're asking me, but there's a period when persons are allowed to send queries, or we may ask persons to clarify
Clarifications. Yes.
submissions.
Yes. Other than clarifications in respect of submissions, there was no requirement to submit any additional material in this tender process, was there?
Not as far as I know.
Not as far as you know,
No, there was
but
no
aren't
requirement.
you? Right,
So
aren't you the man with the, aren't you the drafter? Sorry,
So
go ahead.
if sorry, if I may respond to that, under normal practice, once a tender closes, typically bidders are not allowed to submit anything additional. That's my understanding.
Yeah, unless there's a clarification.
Yeah,
Request and
outside of a
whatnot.
clarification, yes, correct.
And you drafted these tender documents, yes?
I was part of the process of putting the tender together.
What did you say, sir?
I didn't draft the document.
Okay, you compiled the document?
No, I did not compile the document.
Okay, let's go on. Okay, well, we're going to go here. I was just going to take your word for what you had put. So let's go to what you said then. Right, so you led the overall research, design, scope development, request for project approval, and preparation of the tender documents in tender number 25030. Is that correct?
That is correct.
And that included the instructions to tenderers. You led this development. Instructions to tenderers, scope of works, specifications, information to be supplied by the tenderer, safety specifications, form of tender, form of cost breakdown, technical assessment schedule, sample agreement, and general conditions of contract.
That is correct.
You led the development of that.
Yes.
Yeah. And so you know that in this tender document, there was no requirement to put any additional material before, after the closing of the bids. Yes?
Correct.
Right. So let's go back to this paragraph 17 here, because I want to be fair to you. I want to understand when you say presentation material, that the reevaluation committee relied exclusively on the information contained in the original tender submissions, together with the presentation material and contemporaneous documentation. What are you referring to there?
In terms of the contemporaneous documentation?
And the presentation material.
Right, so this would have included any records produced in the original, any records produced from the presentation.
So there were records produced from the presentation?
Well, based on what is coming from the committee, I can't say for sure because I did not look at that myself.
You can't say for sure, but you swore you did a certificate of truth on this witness statement, not so?
Yes, ma'am.
So you put things in here that you're not sure about.
Presentation material, yes, based on what came from the committee, I would say yes.
You would say yes, what?
Based on what came from the committee, my interactions with the committee.
Yeah, based on what came from the committee, what?
I'm sure I'm following you.
Yeah,
I want to make
what
sure
are
I'm on the
you
same
saying?
page with you.
I want to be on the same page with you too. Okay, so let's get there. Presentation material. So in addition to the original tender submissions, you're saying that there was presentation material?
No, I'm just saying that there were things like the attendance records.
Okay, good. You also
Right.
have that, but you put that
Yes.
separate from presentation material.
Yes.
Right, so there was presentation material.
Yes, I would take it that there was presentation material. Yes,
No, you would take it or there was?
I would say there was.
All right, that's interesting. And contemporaneous documentation. So there was also contemporaneous documentation.
Right, so that would refer to any other related documents that were originally submitted.
Related documents that were originally submitted.
Yes, ma'am.
Because isn't it true that the presentation was based and could only lawfully be based on what was originally submitted in November 2025?
I would say yes.
Yeah, because bidders couldn't come at a presentation and add more information and give you more information, could they?
No, additional information, no.
Thank you. So everything in the presentation would have been in the material. Now, in your statement, you spoke about a lot of different things that you did, but I noted you were not responsible for the debriefing, responding to the debriefing request. Is that so? After the second evaluation, is that correct?
Could you refer me to that, please? Just so
All
that
right,
I'm on the
it's
same
at
page with you.
page 1232 of the bundle. Page 1232 of the bundle. Now, there was a second evaluation of these tender documents, correct, sir?
Yes.
Dr. Rose, sorry, let's wait to make sure we get it on the screen first.
It's on the screen.
He sent
It's
a
on the screen.
report, right?
Yeah.
So he didn't
So-
respond to his question related to the document.
Yeah. So I'm putting some context now to the document. So, Mr. Leslie, there was a sorry? Yeah, Mr. Leslie, there was a second evaluation process, yes?
Yes.
And after that second evaluation process, a notice of decision to award was sent out to the applicant, correct?
That is correct.
And after that, the applicant sent a debriefing request.
Yes.
Were you responsible for responding to the debriefing request?
You clarify that responsibility, please.
Clarify the responsibility. No, I'd like you to clarify. Were you responsible for responding to that debriefing request?
I can tell you that I ensured that that response was provided.
And did you ensure that the response that was provided was accurate?
I reviewed it. So yes, I would say yes, I would ensure that it was accurate.
All right. So do you see it on the screen there? Tender 25030 reevaluate and standstill period query.
Yes, I'm seeing a table, part of a table that has query with a number 1 in there.
And you're familiar with it? We can scroll up. We can continue to scroll down the document, please.
Yes,
Yeah,
I'm
that's the
familiar with this.
document that you caused to be produced and sent to the applicant.
Yes, I'm familiar
Yes?
with this.
Right. And if we can go to page 1232, right there. 232? No, correct. 1235. 1235, which is the last page of this document. Yes, and if we can scroll down. Okay, at point 8. You see at point 8, Jian had asked for the basis, the applicant had asked for the basis of the presentation demonstration score, where you all gave him 0 and 0. The remaining 2 zeros. You see that he asked for the basis, they asked for the basis, and there in the response, you all said material relied upon, given that no further presentation or demonstration was requested or conducted. Do you see what is said there? A further presentation demonstration was not conducted since the original data submitted by the bidder was used as documented in the original evaluation report. Would you say
Yes,
that is correct?
I'm seeing that.
Is that correct?
If I were to read it as it is, I would say that the response is correct.
And the response doesn't say anything about contemporaneous documents. Does
No,
it?
it doesn't. No.
Or other material. Can the witness be sure? Did you give instructions to your counsel about presentation material and all of that?
Specific instructions to counsel about presentation material.
Yes,
I don't-
because you are the one in your paragraph 17 and 18 and 20, you spoke about all of this thing that, I mean, we haven't seen anywhere else. So I'm really trying to understand what you're trying to say. Yes?
Right.
Did you look at the Form 9 that was filed, the reply that was filed by your organization?
I had a look at it, yes.
And did you check to see that it was accurate and correct?
At the time, I did a check, and the information in there, as far as I know, was accurate and correct.
All right. Form 9. 1245 of the bundle, please. Can it be shown to the witness? One, 2, 4, 5. Yes. So we're going down to page 8 of the. Can you scroll it? So it's a page number for that. Page 8 of the Form 9. 1252. 1252. 1252. Yeah, paragraph 229. Right, so that would be lower down,
Right.
XXIX. Yeah. So you see XXIX 29. No further presentation or demonstration was requested or held during the reevaluation. The reevaluation committee relied on the original bidder data and the presentation material recorded in the original evaluation report and attendance records. You see that?
Yes.
And would that be accurate?
That would be accurate insofar as the presentation material being available to the committee, I would say yes.
Presentation material recorded in the original evaluation report.
So I read this as two different things. The recording of information in the original evaluation report is separate from the presentation material being available to this committee. That's how I'm reading this.
So there is additional presentation material.
I don't know that to be so. I would say no.
And you cannot say yes.
And I can't say yes. I can definitely say no.
No, there was no additional presentation material.
No, there was no additional presentation material. Correct.
All right. Right, with that said, Madam Chair, I believe that is it for me and this witness.
Thank you very much, Dr. Rose. The Jian, do you have any exact data?
No, no, Madam Chair.
Discuss it.
Yeah, wait a minute.
Mr. Letty, please hold on a bit.
Sure.
Panel has some questions.
Yes, ma'am.
So, Mr. Lepke, you were involved in the selection of the second panel, evaluation panel.
I'm sorry, I'm hearing someone speaking, but I'm not seeing
Were
the person. Okay, yes,
panel?
ma'am.
Yes. Were you involved in the selection of the evaluation panel, the second panel?
Yes, ma'am.
Okay, so if you could help me with the designations, it's a technical assistant one.
That is correct.
More experience and technical assistant two. Okay. So would you say that the second panel was different to the first panel, in terms of competencies? So if I have here, so in the original committee, there were 3 technical assistants, 2 technical assistants 1 and 1 technical assistants 2.
Yes.
Yes. And in the second panel, you had a corporate manager and 2 technical assistant 1.
Could you repeat the question?
How would you compare the 2 committees in terms of competency, equivalent, or would you say that the second committee had a higher level of expertise, or how would you rate it?
I would say that both committees would have had just about the same level of competence to assess the tender.
Okay. So in the evaluation of price, what were the checks that were done? I saw arithmetical checks were done. Were there any other checks that you compared? I didn't see anything mentioned in terms of evaluation of the rates or comparison, or after the arithmetical checks, any other checks were done?
As far as I recall, the only checks that were done on, are you referring to the second evaluation only?
Second evaluation.
Right. So as far as I'm aware, and based on the report, they only did the arithmetical checks to ensure that everything was correctly submitted, accurately submitted. And then the evaluation of the submitted bids would have proceeded from there.
So once we know that you had an internal estimate that was not listed, did
Yes.
the committee have any discussion or concern that the bids in front of them were significantly lower than the company estimate? Were there any questions of underbidding?
In terms of the internal estimate, that was not, as far as I know, considered in the second evaluation. And that lack of consideration, if I could call it that, was based on the provisions of the consent order. So this is as far as I'm aware.
And in terms of the schedule, in the information for tenderers at item E14, the tenderers are required to provide a construction schedule, and that time would be factored into the tender evaluation. How is that factored in? Because I didn't see any mention of how you review how the construction. This would be what I could consider a published criteria. How is it factored into the evaluation of schedule?
Okay, so based on what was submitted by the committee, while the committee appeared to have the discretion to look at that, I did not see any explicit reference to it in their work, and all of their determinations would have been based, apart from their own discretion, on what was in the consent order.
No, so schedule was a specific item that had 4%, I think, marks. Yeah, I think it was 4%. But yet, I think one, which is Jian, got 0. And I think it was on the basis that if published criterion did not have a methodology, right? Then they would get full marks, and if not, you can get 0 if a tender did not meet the requirement. So in this particular one, where you have a schedule has been submitted, and it was stated that that schedule would be considered in evaluation. How was it considered?
I do not know.
Because, I think because there should be a reasoning as to why the marks were given as they were given. Because this is a criterion that was stated.
And you're referring specifically to schedule, correct?
Yeah.
I don't recall them getting 0 for a schedule component.
There is under ease of implementation, I think.
Okay. Are you referring to ease of implementation under the methodology criterion?
I need help here. There's a table that has it was the risk, it was schedule, and the first item. Table is the evaluation criterion table.
Would you mind referring me to the item that we are looking at, please, ma'am?
Yeah, I'll have to find it. Give us a minute. You'll find
Sure.
it first. Cool. So if I could go on to another question which relates to while she finds the presentation. So the second committee decided not to conduct in-person presentation for efficiency, cost, and time. So I assume that they reviewed presentation material, which the attorney, Dr. Rose, was inquiring as to what that presentation material would have been that the second committee would have reviewed to change the scores. Because there's no mention as to what was the reasoning for that particular rating.
Oh, I'm sorry, my mic was muted. Okay, could you repeat the question, please?
On okay. In the instructions or the information for tenderers, it was proposed to conduct a presentation in person.
Yes.
In the first evaluation. The second committee decided they did not need to conduct an in-person.
Yes.
And that they would review the original materials. If that criteria required an in-person presentation, what did the committee use in order to change, evaluate, and recognize that they wanted to change the rating?
Oh, I see your question. I am not sure what material they would have referred to. I don't recall.
Appendix 2. Okay. Page 14. Page 14 of the above. So you don't have the information for that. I don't know if other panel members have a question while we try and find that schedule for you.
Sure.
Right. So we have to put it up on the screen. For some minutes. So we're gonna put it up on the screen for you to look at Mr. Leslie. We prefer
Yes,
you
sure.
look at the document in place on the screen rather than anything you have before you, right?
Yes, Chair.
If you look at, can you scroll it up a little more? So if you look at this screen here, which shows what the points were according to your rubric, 2.2% for presentation and professionalism, 4% for ease of expandability, and 4% for ease of implementation and maintenance.
Yes.
4%. Oh. And in terms of if you look at the revised marks compared to the first marks for presentation, the mark was changed for presentation for Jian Enterprises. And so the question I had for you is, if they did not have, what was the material that was used to change that score?
Okay, so you're asking what material the re-evaluation committee used to make a determination
To
here.
change the score.
All right, so as far as I'm aware, the re-evaluation committee operated completely independently of the original assessment. The material that they used to determine the scores, I can't say that I'm sure or that I recall what material was used by the committee in particular.
Were the presentations recorded? Do you know?
I can't say for sure, I wasn't present.
And then if you look at the third item, which is implementation and maintenance with a score of 4.
Yes.
And where I pointed you to a statement in the information to tenderers that the submission of a schedule would be used in the evaluation. And and it was stated that all they complied with submitting this implementation schedule. So on what basis, or how would you, how did that translate to a score of 0?
All right. So my understanding is that the committee would have used whatever information was available to it, that this is the re-evaluation committee, and operating independently of the original evaluation, they would have made a determination on all of our various scoring criteria. That's the first part of it, right? With respect to the determination of either full marks or 0 marks, from what I understand, the committee, having regard to the provisions of the consent order entered into between the parties, the committee would have considered that either the bidder met the requirement or the bidder did not meet the requirement. And because of the limitations applied through the provision of the consent order, there was no opportunity to scale a response. So it's either the bidder met the criterion and therefore was awarded full score, or didn't meet the criterion and was awarded a mark, or was not awarded a mark. I'll put it like that. That's how I understand the committee approach these, the re-evaluation process.
Before Ms. Klasik proceed, I just want to have a question before you proceed. Could you clarify what you mean by from your understanding? Where did you get the information from? Because I'm
Right.
a bit more
I'm sorry, I didn't mean to cut.
Yes, no, proceed. So there are two responses you gave. You said from my understanding. Can you tell us the source of the information?
Yes, so based on the advice that was received internally, based on our reading of the provisions of the consent order.
No, sir. I don't think you understand me. I want to know, Ms. Kalsik asked you about how the committee went about assessing.
Yes.
Your response was from my understanding. So what I want to know is, where did you derive your understanding? Is it that
I
someone told you this? Let us know whom. That's what we want to try to find out.
Right. So my understanding comes from how the report is written, from the committee's application of what was presented to it. So that's where my understanding of this matter comes from, this aspect of it.
Thank you.
You're welcome.
Okay, my last question really is perhaps as you so you have 10 years experience in your current job.
Yes,
Your
ma'am,
current
in this position. Yes.
But your total experience as an engineer is what, like at least 20 years?
26 years.
26 years, okay. And so in your pricing this has a heavy weighting of 40%. But yet in an evaluation, it was not different. It did not allow a differentiation.
Yes.
Does this give a value for money? Does this give a value when price is somewhat nullified? I mean, I understand the consent order, but in the outcome, in your final outcome, how do you see this approach as giving you a value for money?
How do I approach this answer? I would say that on the basis of all my experience and knowledge of these systems, I would say that this procurement, if we were to go in this direction, will in fact give us value for money.
You add to that, what basis? Why would you say that?
All right, so on the basis of the whole of the situation that we are in and the market and so on, I would say that it falls within the realm of reasonable value for money.
Not necessarily competitive.
I'm not sure how to respond. I can't say that I can definitively say yes or no to its competitiveness.
Okay. Then.
Madam Chair, why, may I
Yes.
ask why the witnesses microphone is muted right now?
Mr. Leslie, you are giving evidence. You have to leave your microphone on and you to look into the camera. You're not to look into any document.
Absolutely.
Right? You're still on the oath.
Yes, ma'am.
Right. I just want to piggyback off of what my panel member asked, right? Basically not having scored the price. Do you agree? Or do you still think that you are going to have gotten the best value for money? Because the price, which is 40%, was either pass, zero, or total marks, not having scored it.
Yes.
Or the yes is in response or in response to me repeating the question?
I'm sorry, I thought you were still going. Right, so the yes was in response to you asking a question.
Okay, you got the question or I need to repeat it?
Would you mind repeating it, please?
So, not having scored the bidders for price, which was 40% of the score, do you think you were able to get the best value for money on this procurement?
If I were to give this some further thought, I would suggest that, now I know you're asking me a yes or no question, but if with your leave, I would just ask if I can expand on the response. Would that be okay?
Oh, you could expand on the response. You could expand on the response.
If our
So you can tell me yes
circumstances,
or no and why.
I would say I'm not sure because this is a peculiar situation. And on the basis of everything that's in front of us, I would say that we are still in a position to receive value for money here. When I consider,
Answer.
pardon me?
That's zeroing. You answered Ms. Kelsey as it relates to value for money. I specifically asked about, do you think you got the best value for money as it relates to this procurement? So we're not talking generally, I'm zeroing on best value for money.
I would say that we are close to getting best value. That's as best as I can respond to you.
Okay. I have no further questions. Yes, that's it. Right. Thank you very much. Miss hold on, you're not leaving us yet. So let's see. Any questions, Dr. Rose or Mr. Jackman?
No, please.
No,
Any
please.
examination, Mr. Jackman? Okay.
No, please,
So
ma'am.
thank you very much, Mr. Leslie. Mr. Leslie,
Thank
you're
you.
relieved as a witness. And
All right.
you can leave. You can come off the list now if you want to. You can stay if you want.
All right. Thank you very
Thank
much.
you very much. to the parties and their representatives. We are going to give you all some directions for filing, or is it that you all still want to make sure closing statements at this stage? I
I'm
know
happy
Dr.
to
Rose,
file.
what's the Jago?
For the respondent, we will be happy with a direction to file our written submissions.
Oh, right. So, as you all are aware, we have to give a decision by the 14th. So we're going to give directions to file closing arguments. You don't have to repeat the skeleton. You can rely on that as well, but you can expand by the 11th. And I would say as well, we will give you all until 6 o'clock on the 11th. Now, bear in mind the difficulty we experience when you all ask for the extension after the time, because the filing team will not accept it for filing. If it's out of time, they have to contact the panel for us to make an order first. So if you're having a difficulty, yes, Mr. Jacob.
Sorry, Madam Chair, I don't mean to interrupt. I'm just wondering, in anticipation of maybe perhaps needing any requests that may come from either side, would it be more helpful if we file on the morning of the 12th?
Okay, so we can give you all, but we have to get it by 8 a.m. because we would need to deliberate.
Yeah, yes, please, Madam Chair. I think
Right.
that is
right?
reasonable.
And the difficulty is when you, right? You have to, we have to comply to the 8 a.m. filing deadline.
Yes, Madam Chair.
What I was saying is that in instances when you need the extension, and we're hoping we don't have any request for extension with the 8 a.m., but it's always prudent to request it before because they wouldn't accept it for filing if there's an order. They have to get the team together, the panel together to make an order to vary the directions first, right?
Yes, Madam Chair.
So by 8
Yes,
a.m.
Madam Chair.
on the 12th, by 8
Yes,
a.m.
please.
on the 12th, and we will deliver a decision by the 14th. Any questions, any concerns?
No, Madam Chair.
No, Madam Chair.
Right, and you are free to address us on the other issues. Dr. Rose, I know we promised you the reasons for the application, for dismissing the application. If you want to put in submissions as it relates to that, you're free to put that in there. And similarly, you, Mr. Jaku, you can put that in as well for opposing. But
Yes,
we will
please.
elaborate on the reasons that we gave earlier in the reasons.
Yes, Madam Chair. Understood.
Yeah. Yes, Madam Chair.
Well, thank you very much. Unless there's anything further, we will, this is the end of today's hearing. We'd like to thank all the parties and their representatives for assisting the panel and all the best, and we look out for these submissions.
Obliged.
you,
Have a
Madam
good
Chair.
evening, members of the panel.
Have a good evening, everyone.
Thank you, Madam Chair, and have a good day to you.